Yes.
May it please your lordship. Lordship, with the consent of the other side, we had circulated an adjournment request, your lordship, with regards to item number 7, your lordship. Lordship, my senior Mr. K. N. Chaudhary is unavailable today. Therefore, I kindly seek some time.
So in this case, Lordship, notice was issued. We received the copy day before yesterday. So we may be given 3 weeks time to file the reply. Adjournment is of no difficulty. In any case, we will be.
Otherwise, also they are seeking adjournment.
Yes, Lordship. So 3 weeks time may be given in the first week of April, Lordship, may be pleased to fix it.
Lordship, I am under instruction to pay for some earlier time, your lordship, by the end of this month. Your lordship.
I am not available, Lordship, till 31st.
And what is your name?
T. Kashyap, your lordship.
Mr. T. Kashyap, learned counsel for the appellant who seeks an adjournment on the ground of personal difficulty of the senior counsel for the appellant. Stop. On the other hand, Mr. D. Saikya, learned senior counsel, you are appearing for?
For the Honorable Chief Minister, it's only one.
Appearing for respondent number 1, also seeks, also submits that he has, that the respondent number 1 has received the notice
2 days ago.
only 2 days ago and seeks time to file their written objection in this appeal. 3 weeks. List this matter on 1st of April.
Lordship. Deeply obliged, Lordship.
This item may be listed for the reporter local lordship. Already matter is compromised.
Which one?
MSC appeal number 452 of 2023.
Okay.
May I please, your lordship? Lordship, I beg to mention.
But for Mr. Bhutto, for sending it to Lok Adalat, there has to be some orders. Some order has to pass. Or only by mention memo it may be listed. We'll list it tomorrow and then pass an order for
Yes.
list it tomorrow.
May I please, your lordship? Lordship, I beg to mention for listing an IA for lordship. So maybe matter listed for listed on Friday, lordship.
What
I for withdrawal of FDR, lordship. But there is an urgent need of money, lordship, for higher education, lordship.
Okay, Friday.
Obliged, lordship.
May I please, your lordship? Lordship, I would like to beg for item number 38 with the consent of the other side. Lordship, we are for insurance company and we need time for filing an objection regarding their additional evidence on affidavit. Lordship may kindly pass another.
You have informed the other side.
Yes, Lordship. Lordship, I am standing for the appellant. We will submit a copy today.
What is your name?
D. Hazarika.
What Miss B. Hajarika?
D. Hazarika.
D. Hajarika. Item number 38.
Yes, Lordship.
D. Hajarika, learned counsel for the
Insurance company. Respond.
learned
behalf
counsel
of
for the
Respond.
insurance company. Prays for an adjournment on the ground that they intend to file an interlocutory application in this case. She submits that she has informed the counsel for other side regarding her prayer for adjournment, who does not have any objection to the same. Hence the prayer is allowed. Let this matter be listed when? 19th of March.
Okay.
May it please your lordship, I beg to mention item number 23, lordship. Kindly pass over the matter for the day, lordship.
Why?
Today is some difficult day, lordship.
You are for?
On behalf of T. Som, lordship.
You have informed the other side. Ms. Majumdar, you have any objection? Item number 23.
They haven't informed us. They always mention without informing and they are taking time. This is a delay petition, Dinamani Das. I do have objection, but Lordship will allow them.
What is your name?
A Mohanto.
While making mentioning, you should inform the others.
Yes. And they have
Uh,
his phone number.
Heard Miss A.
Mohanto.
Mahanta Learned Counsel for the applicant who prays for an adjournment on the ground of personal difficulty of the conducting counsel. Also heard Miss R.D. Majumdar, Learned Counsel for the insurance company, who submits that she had not been informed earlier regarding the mention regarding the prayer for adjournment by the applicant. Stop. However, considering the submissions made by the learned counsel for the applicant, the prayer is allowed. Let this matter 19th of March.
Obliged.
Please, your lordship. Your lordship, I beg for listing of two MSc appeal for in orders column,
When?
18th.
18th March.
Yes.
Okay.
Obliged.
Mr. Lordship, I beg to mention for listing of a IA Lordship.
When?
Any date Lordship.
18th March in orders column.
Your Lordship, if you may please adjourn the item number 31. As my senior is out of station today.
Have you? Okay, what is your name?
Thesis Bavisho,
Yes,
PHAI. Thesis Bavisho.
write his name. Learned counsel for the applicant seeks an adjournment on the ground that conducting counsel for the applicant is out of station. The prayer is allowed. Let this matter be listed.
Much obliged.
23rd of March.
Please, your Lordship. Lordship, I beg to mention for listing of MSc appeals on 16/3/2000.
In orders column.
Huh?
Orders column. Okay.
No, it's-
Lordship, I beg to mention item number 26, your Lordship. The main suit through which this appeal had come, your Lordship, has been disposed of. Therefore, the.
You are appealant. Appellant.
Yes, your Lordship. FAO.
You are for the appellant.
Yes, your Lordship.
Heard Mr. A. Mishra
On behalf of Mr. Estes.
submitting on behalf of Mr. S. Das, who submits that the suit in which the order which has been impugned in this appeal was passed has already been disposed of, and therefore this appeal has become infructuous. Stop. Considering the submissions made by learned counsel for the appellant, this appeal is disposed of on becoming infructuous.
Deeply obliged.
May I please, your lordship? Lordship, I beg to mention item number 40, my lord. My lord, this IA has been filed for condonation of delay, my lord. My lord, this notice was issued, my lord. We have taken steps, my lord. The service report is awaited, my lord. So may I pray this matter may be taken up after a week or 2 weeks, my lord.
You have gone through the
Yes,
office note.
I've gone through the office note, my lord. The service report is awaited, my lord.
When have you taken steps?
Lord, we have taken steps on, my lord, in the last, my lord, of February, my lord.
Heard
A.
Miss-
Sharma, my lord.
Mr. A. N. Sharma, learned counsel for the applicant, who submits that the notice issued to the respondents have not returned, and he prays for awaiting the service report. Stop. The registry is directed to place the postal track consignment report of notice sent to the respondent by speed post on the next date fixed. Let this matter be listed on 20th of March.
My lord. I'm obliged, my lord.
PP 9. These are the regular notice.
For reference to the special mediation right, item number 1.
Can it be referred?
Your Lordship, I am appearing on behalf of P. Hajorika. Your Lordship, the appeal has been preferred by the claimant. This matter may not be referred to the mediation as few law points are involved, Your Lordship.
Yes.
I am for respondent number one, Lordship, National Insurance Company.
What is your submission?
It is,
Respondent number one means
policy is not called, Lordship, unregistered, it was an unregistered car, Lordship.
Your Lordship, this matter may be listed for hearing as.
Miss, what is your name?
Your Lordship, B. Thakuya.
Heard Miss B. Thakuria, learned counsel for the appellant. Also heard Mr.
S. Pegu,
S. Pegu,
on behalf of.
appearing for respondent number
One.
one. Though this matter has been listed today to see if there is any possibility of referring the same for mediation under special drive for mediation, however, learned counsel for the parties submits that since there are certain law points involved in this case which needs adjudication by court, this is not a fit matter. Putul, this is not a fit matter. This is not a fit matter to refer the same to mediation. Considering the submissions made by learned counsel for the parties, let this, otherwise it is ready for hearing. Is it ready? Yes. Let this matter be listed for hearing after 4 weeks on a date to be fixed by registry.
Much obliged.
Item two.
Lordship, the matter is already in hearing stage, Lordship. It is not a big case for mediation.
Why?
Lordship, because the claimant and the deceased are not a third party, Lordship. That is one of the ground that we have taken. And there are other law points also, Lordship.
Yes, Mr. Padgiri. Heard Mr. S. P. Sharma, learned counsel for the appellant. Also heard Mr. K. R. Padgiri, learned counsel for the respondent / claimant. Though this matter has been listed today to ascertain if there are any possibility of referring the same to for mediation under special drive for mediation. However, it is submitted at bar that this matter is already ready for hearing and certain law points are involved in this case which needs to be adjudicated by the court. Hence, this matter is not referred to mediation. Let this matter be listed for hearing
That may be fixed. Already fixed on.
7th of May.
My lord, claimant number one, my lord, respondent already died, my lord. I informed that, my lord, appellant, my lord. But his name may be struck off, my lord.
Lordship,
Respondent number one.
as per order dated 17/9/25, Lordship, I could not go to the records, Lordship. It is already striked already.
But amended cost title may be required, my lord, for submitting, my lord.
No, registry will strike out the
My
name.
lord, he has to, my lord, submit the amended cost title, my lord.
No, not necessary. In striking out, registry may strike out the name if there is no substitution.
My lord. But in causeless, my lord,
Stop.
till that, my lord.
It appears from record that by order dated 17/9/2025, the name of respondent number one was directed to be struck off. Stop. Registry shall strike out the name of the respondent number one in the memo of appeal as well as from the records,
My lord.
list accordingly.
Obliged.
Item three.
Yes.
My lord, I plead that the matter is not fit for mediation.
Why?
The matter has been disposed by the lower court on the failure to prove the degree of preponderance of probability.
Lordship, claim petition was dismissed, your lordship.
Yes,
Claim petition was dismissed, your lordship.
on their claim petition was dismissed.
That's why.
Okay.
Lordship, I am
Then-
appearing for respondent number 1
Third, Mr. What is your name?
This is Bobby Show, appearing for AG Chowdhury.
Learned counsel for the claimant.
No.
Learned counsel for the
Petition.
appellant. Also had Ms. P. Bauthakur, learned counsel for respondent.
Respondent number 1, your lordship.
Respondent number 1. Though this matter was listed today to ascertain the possibility of referring this matter for mediation. However, after going through the materials on record as well as the memo of appeal, this matter is found not to be fit to be referred for mediation. Accordingly, release this matter for hearing on 12th of May.
Okay, sir.
Supplies, my lord.
Admission item 4.
May I please, your lordship? Your lordship, my claim has been dismissed by the learned tribunal.
Okay, heard Mr. D. Mondol, learned counsel for the appellant. This appeal under section 173 of Motor Vehicles Act 1988 has been filed by the appellant Debojit Deka, impugning the judgment and order dated 9/6/2023 passed by the Motor Accident Claims Tribunal, Kamrup Amingaon, in MSC case number 183/2018, whereby the claim petition filed by the present appellant was dismissed. I have gone through the grounds taken by the appellant in the memo of appeal and heard learned counsel. Stop. This appeal is admitted. Issue notice to the respondents and call for the records of MSC case number 183/2018. The registry shall take steps for requisitioning the aforesaid records. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 6th of April.
Highly obliged.
Item 5.
May it please, the lordship? My lord, please. Yes. My lord, this is an appeal filed by the owner and against the order passed against him, my lord. Now, my lord, if I may, my lord, the core issue which involves in this appeal, apart from the other issues, are this that sufficiency of evidence whether the owner was given an opportunity to produce sufficient defense witnesses. That is one of the core issues which are there. Now, for that matter, my lord, if my lord turns to 107 page number for a moment, and I'll just demonstrate one line from that, and probably then I will take this honorable court through the order if honorable court feels so. Now, page number 107, my lord, if
You are directed to pay.
yes, my lord, I am the owner. I am directed to pay. My lord. My lord is there, page number 107, my lord. My lord will see it is an order of review. Now, in that order, my lord, the last few lines, my lord, if I may read. My lord has come to the page number 107. Yes. Dealing with the review petition to revisit the question of adequacy of opportunity given to the owner present petitioner for adducing evidence, I may note in this context that when my learned predecessors proceed with to the next stage of hearing, the evidence of DW was closed by the necessary implication, though no express order has been passed in this regard. And even if I am of the view that
Your review was dismissed.
well, I'll come to that. I'll come to that, my lord.
Yes.
If I may wish, my lord will bear me for 1 minute more, my lord. Even if I am of the view that sufficient opportunity was not given to the owner, present petitioner for adducing evidence, I cannot substitute that view.
Now, my lord, what has happened here is this, my lord. So, one of the central issues which revolves around this entire case is that whether the owner was given sufficient opportunity to adduce his evidences. My lord, if I may, my lord.
Yes.
My lord.
No, you are challenging the original.
I am challenging the original order.
Okay.
Yes, my lord.
Okay.
Now, in the original order, what has happened, my lord? I could not produce my insurance document at the time of while I filed my WS. The reason behind is this, my lord. If my lord now sees the order, and my lord will find the order in page number, my lord. Sorry, my lord. 68. It's a peculiar case, my lord, because page number 68, my lord has got it. Now, that is the impugned order, my lord. Now, I come to para number 2 for a moment, and let me read para number 2 for a moment, my lord. Then I'll demonstrate what I am trying to lay emphasis upon. The brief case leading to the file of application under the garb of 166 of Motor Vehicle Act may be succinctly stated that on 21/1/2005, disease went to purchase some goods from the nearby shop, but when he reached such and such place in front of a house of one Pyari Mahajan, all of a sudden an offending vehicle, number Iman such and such, which proceeding from Silchar side towards Kaline, being driven by the driver in a rash and negligent manner by overtaking other vehicle, the driver lost control over the vehicle and knocked the disease by leaving its side. As a result, disease sustained grievous injuries on his person and was immediately shifted to the Kaline hospital. But since the condition was serious, the disease referred to the SMCH, but on the way to the SMCH, disease succumbed to his injuries. Thereafter, post-mortem examination of the dead body was conducted at SMCH. In connection to that, Katigora PS number 27 of 2005, my lord. And the MSCT case is filed in the year 2015, my lord, after the gap of 10 good years. In the meantime, my lord, I sold my vehicle in the year 2009. I'm just giving an bird's eye view of the matter, my lord, what has happened in this case. Thereafter, my lord, I could not produce the insurance papers which were there because that got shifted. During the proceedings of the trial, my advocate also expired. And the defense witness was if my lord turns to page number 52, 2 PWs were examined.
By whom?
By me. 2 PWs, I'm sorry, my lord. The claimant sides examined 2 PWs. One was the mother and one was one supposed eyewitness. That order sheet is there in page number 52. And thereafter, my lord, an opportunity was given to give the defense witness. My lord will see in that page number 52. That on that day, on the next page, that is 53, my lord, my evidence, they produced some other documents, page number 53. That is the order dated 31/10/2027. Without giving me an opportunity to produce my defense witnesses, it was closed. It was closed, my lord. What has been done here is that the other side was given an opportunity to produce some certified copy, my lord. I have attached all the certified copies of that order sheets. My lord will call for the LCR. My lord, the LCR will demonstrate what has happened. And till the matter was proceeding in this manner, each and every date, they were taking some time or other to produce certified copies. That they ultimately did, but in that process, my right to produce defense witnesses was foregone, my lord. Unfortunately, my advocate died in the meantime. I could not produce this important piece of document, that is the insurance papers, which I produced at the time of review. My review got dismissed because on the simple ground that the reviewing authority said, look, I cannot go behind the original order, because that will tantamounting to opening of a new trial. Hence, I am before this honorable court. So
Ultimately,
what I am
the
seeking,
impugn judgment was passed on which date?
my lord, that was passed on, my lord, 19/7/2022, my lord.
So for 5 years,
My lord,
you
they,
why you have not
yes,
raised?
my lord, exactly. I'll answer that question, my lord. My advocate expired in that meantime.
But 5 years is too long.
Because, my lord, I did not knew that what has happened, what was happening in the case. There were other grounds also. I will demonstrate other grounds are there. If there is a delay on my part, my lord, I can explain that delay. But the lacuna in this case, that after a period of 10 years, the eyewitness, which was, it's basically a got up witness.
Heard Mr. A.B. Day, learned counsel for the appellant. This appeal under section 173 of a Motor Vehicles Act has been filed by the owner of the offending vehicle, namely Krishnendu Chakravarti, impugning the judgment and order dated 19/7/2022, passed by the Motor Accident Claims Tribunal, Kachar, Silchar in MSC case number 1117/2015, whereby the appellant was directed to pay a compensation
4 lakhs, 9.
amount of rupees 4,83,000 to the claimants, along with interest at the rate of 6% per annum.
7%.
You have mentioned 6%.
Sorry, my lord.
Is it 7 or 6?
7, my lord.
7% per annum.
Oh, I'm sorry, it is 6%. My lord. In the one page, he is written 6%. That quoted.
6% per annum. So I have gone through the grounds stated in the memo of appeal and heard learned counsel for the appellant. This appeal is admitted for hearing.
Other sides have appeared, my lord, already.
Where
My lord,
is the
the
first?
last occasion, I think somebody appeared from the insurance company. My lord will peruse the last order.
You have served notice on
Yes,
her?
my lord. Yes, I have given the copy also of appeal to her and also to the other side also, my lord. LCR may be called, my lord. Last occasion, the LCR was also called.
No, to other councils.
Yes, my lord. Also to the other councils, I have given a copy, my lord.
Where?
I have given the copy of appeal memo, my lord. They have already, their name is already reflected in the.
No, but notice has not been issued. Only Miss L. Sharma of the insurance company, she has appeared. Claimants notice.
Claims, my lord, I think name of in the cause list, my lord.
Was there any delay in filing this appeal?
Yes, my lord, there is a delay in the.
So they might have appeared in the condonation application.
But in the EA, their name is reflecting, my lord, against the appeal memo, my lord.
No, you have to.
In the cause list, my lord, their name is appearing.
But order sheet does not reflect anything.
Oh, my lord. My lord, then.
Issue notice to the respondents. Since from order dated 4/2/2026, it appears that Miss L. Sharma had already appeared for insurance company. No formal notice need to be sent to the insurance company. Learned counsel for the appellant has also submitted that he has already furnished the memo of appeal along with annexures to the learned counsel for the insurance company. Name of who is appearing for insurance company?
My lord, I think L. Sharma had appeared on the last occasion, my lord.
You inform her personally.
Okay, my lord, I will inform her today.
Name of Miss L. Sharma may be reflected in the cause list as counsel for insurance company henceforth. As regards the other respondents, issue notice. Stop. The appellant shall take steps for issuance of notice upon the other respondents.
My lord, already R. Sharma and he appeared, my lord, in the cause list also, my lord.
No, that is wrong reflection.
My lord, I'll take steps.
The appellant shall take steps for issuance of notice on the respondent number 1, 2, and 3 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 20th of April.
My lord, can it be on 20? No problem, my lord.
When?
Nothing, my lord.
20 April. Let the records of
LCR may be called.
MSC case number 1175/15 along with no. What is the review?
My lord, review is miss case, my lord, 9/2022.
Along with miss case number 9/2022 be called for from the concerned tribunal. The registry shall take steps for requisitioning the aforementioned records list accordingly.
Item 6. The item number 26, you have not been informed and mentioned.
Item number 20.
I appeared by filing Vakalatnama lordship to inform this court that lordship, this suit is already dismissed and the miscase is already dismissed. They are taking time in the first appeal.
No. They have mentioned that it is dismissed. Therefore, today it is disposed of on becoming infructuous.
Then lordship has passed that already.
Yes.
But then no.
It
They said that it is mentioned lordship.
mentioned, but they were fair in mentioning. They mentioned that suit has been dismissed. Therefore, I have dismissed the appeal.
Lordship. And consequently, all miscases.
Everything will.
Then they have not informed me.
They have not understood properly.
Lordship. I'm sorry. Item 6.
May it please your lordship. Lordship, we have filed this appeal, lordship, because the injured, he did not suffer any disability, lordship, but the court has calculated the compensation as if a disabled person. There was no disability certificate, there no doctor adduced evidence, only the claimant adduced evidence, and the compensation of 5,71,172 is granted.
Ms. Adi Mujumdar, learned counsel for the appellant insurance company. Stop. This appeal under section 173 of MV Act 1988 has been filed by the Oriented Insurance Company Limited, impugning the judgment and award dated 29/7/2025 passed by the Motor Accident Claims Tribunal, Moregaon, in MAC case number 58/2019, whereby the appellant was directed to pay a compensation amount of rupees 5,71,172, along with an interest at the rate of 7.5% per annum, with default interest of 9% per annum. I have gone through the grounds taken in the memo of appeal, as well as heard learned counsel for the appellant. This appeal is admitted. Issue notice to the respondents. The appellant shall take steps for issuance of notice to the respondents by speed post as well as by speed post. Then the
Lordship, AD doesn't come now.
postal track consignment report, it will be,
Registry has to.
yes, speed post within 7 days, both 7 days from the date of this order, returnable on 21/4. Let the records of MAC case number 58/2019B called for from the concerned tribunal. The registry shall take steps for requisitioning the aforesaid records list accordingly.
I'll oblige.
Item 8.
May I please, Your Lord? My lord, I have filed a suit for declaration, lordship, confirmation position, and the permanent injunction, lordship. In the before the trial court, lordship. Along with the plaint, lordship, I have also filed an interrogatory injunction application under Order 39 Rules 1 and 2. After hearing the injunction matter, lordship, the learned trial court passed the impugned order issuing so-called notice, lordship, and stating that matter will be considered after hearing the opposite party, defendant, lordship, against which I have filed the appeal, lordship. Lordship,
When the impugned order was passed,
impugned order was passed, lordship, 16. Your lordship, may please to take up the
when is the next date fixed?
next, is fixed on 24th
24th of
this month.
March.
Earlier, the date was fixed on lordship 2nd of March, and notices summons were served to the defendants, but they did not appear. Then the court has fixed
If
24th.
they
of-
did not appear, court could have proceeded ex parte.
No, nothing. The impugned order is page 43, lordship, of the file. Last page. Last page, lordship, page 43.
Where is the order on second of March?
Second order, lordship,
What happened on 2nd of March?
second, next date has been given, fixing 24th of March.
That order should have been,
Now, before that, lordship,
you filed this case on 2nd of March.
it's 2nd of March. Lordship, I have critically stated in para 26 of the plaint that the defendants on 10th of February 26 tried to dispossess me forcibly and illegally, lordship, by showing the martial power. But on being protested by the appellant's lordship plaintiff, the defendant did not succeed. In spite of that, lordship, the ex parte injunction was not granted, lordship. And your lordship is fully aware, as per the full bench decision of this honorable court, Akmalari versus State of Assam, 84-1 GLR page 133, lordship. If the either granting injunction or refusing injunction, lordship, reasons must be given. That is, the three golden principles of the injunction jurisprudence must be discussed, lordship. Nothing has been discussed, lordship, without discussing the three golden principles, lordship. My petition, the court refused to grant injunction. Lordship, may be pleased to come to para 6. This is a full bench decision, para 6, lordship. Any controversy as to whether reasons need to be recorded while making an ex parte order of interim injunction has been removed by the introduction of the Rule 3, which provides that the court, after recording reasons for satisfaction that the object of granted injunction would be defeated by delay, may pass an order of the ex parte ad interim injunction under Rules 1 and 2 of the Order 39. It does not extend to scrutiny that an ad interim ex parte order devoid of reason rendered in violation of the well-known principle that a judicial order must contain reason, and in violation of the mandatory provisions of the Rule 3 can escape the jurisdiction of the appellate court, but the same order can be revised by the very same court. Judicial order must be reason order. After the amendment, it must contain reasons. The trial court must apply its mind to the materials placed before it and on being satisfied about the requirements of the order 39 rules 1 and 2, make the order. Further, rule 3 enjoins regions to be recorded under these circumstances when the trial court is required by law to state regions but does not furnish them in its order. It violates the principles of the court by its own inaction.
No. Please read the again. The trial court must apply its mind on materials. Further
The
rule
trial court
from
must
from
apply
further
its mind to
further rule
the
3.
material placed before it. That is whatever the statements made in the plaint or the injunction petition before it and on being satisfied. Further, rule 3 enjoins regions to be recorded. Here in the present case in the impugned order, no regions have been given, Lordship.
Now, rule 3 requires reason to be recorded while granting an ex parte injunction.
Yes, Lord.
While refusing ex parte injunction.
While refusing also, Lordship,
Where?
the 3 golden principles must be discussed. Then only.
No, while refusing ex parte injunction, if court chooses to issue notice, whether reasons have to be mentioned or not.
Yes, Lordship.
Show me where.
Yes, yes. Rule 3, Lordship, may be pleased to pay. Order 39 rule 3. And this full bench decision also.
One reasons court might have stated that
Yes, Lordship.
that the case does not.
Lordship, before granting injunction, court to direct notice to the opposite party. The court shall in all cases except where it appears that the object of granting the injunction will be defeated by the delay before granting an injunction, direct notice of the application for the same to be given to the opposite party. Opposite party, provided that where there is it is a proposed to grant an injunction without giving notice of the application to the opposite party, the court should record the reasons for its opinion that the object of granting the injunction would be defeated by delay and require the applicant to take to the.
Yes, well, it means that if court intends to grant ex parte injunction dispensing with the notice, only then reasons have to be mentioned. Plain meaning is that is what I have understood.
No,
if while issuing notice also reasons are to be recorded, you show any authority.
Yes, Lordship. Lordship, I'm pleased to come to take up para 8 of the full bench decision. Para 8. We hold that against an order of the ad interim injunction under section 151 of the code is not available. As order 43 rule 1 is not attracted. Order 43 rule 1R does not provide for appeal against any order of injunction made under section 151 of the code. We hold that, this is important, we hold that an order made under order 39 rule 1 and 2, refusing or granting an ex parte order of ad interim injunction is appellable order. Is appellable order. Rule 43, rule 1 are because the order under order 43 rule 1 R enables a party to prefer an appeal against an order positive or negative. Passed under rule 1, 2, 2A and 4 of the order 13. An order refusing an ad interim injunction is a negative order, but this falls within the expedition and order. The question is no longer res integra in view of the decision of the Supreme Court decision. Then, Lordship, we hold that refusal to grant an ex parte injunction of ad interim injunction is appellable under order 43 rule 1 R of the code. We after citation and next line, we also hold that an appeal lies against an ex parte order of ad interim injunction passed under order 39 rule and 2 4, no matter whether it is short term or long term, speaking or non-speaking, ex parte or inter party. Then Lordship may be pleased to come to.
Last page.
Lordship may be pleased to come to last page.
Last page, para.
Last second line, it is different matter.
Second line is,
Lordship.
okay, in para 10, last page,
A
yes,
continuation of
yes,
para 10.
yes.
It is different matter that all order interim or final should contain reasons, but to regard all non-speaking disposals as not even orders of the appropriate authority which created settlement. As such, disposal might then become non-appealable or non-irrevocable even after the relevant statutory provisions. For the above aforesaid reason, we held that an appeal lies under order 43.
This judgment, to my understanding, only states the law that an order of issuing notice is appealable order.
Yes.
It does not say that that order must contain reason while you issue notice. While you refuse ex parte injunction, nowhere it has been stated. Rather, it has acknowledged that an order issuing notice may be speaking or may not be speaking order.
Lordship, already I have placed before your Lordship that either injunction granted or refused. So it is a deemed refusal, Lordship. It is a deemed refusal.
No,
Then it may be, I will place a Supreme Court decision. It may be taken on day after tomorrow.
okay.
I will place it. There is a.
No, what you want to submit? Your first submission was that even an order issuing notice and denying the ex parte injunction at the first instance should be reasoned order.
Yes.
That I also agree, but where is the authority that
Authority, Lordship, already the full bench judgment your Lordship has paid over.
No, it only says that the order is appealable.
Order is available either granted or refused.
Yes,
Positive or negative. That has
Yes.
been held by the full bench Lordship. So here Lordship, it is a deemed rejection Lordship. Ex parte injunction, deemed rejection Lordship. So when there is
deemed rejection only at the first instance.
a first
A short date was given.
I'll Lordship, the Supreme Court has laid down the law that if the
Why I am
ex
raising
parte
these,
injunction is
why
not-
I am raising these issues? When the court has given a short date, that is on 2nd of March, you could have agitated your case
I
before
have
the
stated
trial
Lordship,
court.
but the learned trial court did not acted as per my submissions, Lordship.
But nothing has been reflected in the orders. Whether you have agitated on the second, when the,
I have personally appeared before the learned trial court.
no, what I want to understand is on the first instance, court issued notice.
Mm.
You prayed for ex parte injunction, that was not granted. It fixed a short date, 2nd of March. In second, your submission is that on 2nd of March, notice were served. If served on the other side, if it were served, you could have prayed for proceeding ex parte.
I had prayed Lordship.
But what was the court's order? That is not before this court.
Even in e-court Lordship, the order dated 2nd of March has not been uploaded Lordship. And this the trial court is of Morigaon Lordship. Even then, I had gone there Lordship. I moved the matter, I prayed for submitting that defendants have not appeared, so my application for granting injunction may be considered. But the learned trial court simply fixed the date, fixing 24th.
What was the order?
Lordship.
What was the order on 2nd of March?
Huh?
You produced
No,
that order.
not been uploaded till date. Till date, the order dated 2nd. Huh? I can produce the certified copy. Till then, Lordship, I may be, because Lordship, I will be evicted. My lease is valid up to 2031. And the defendants are, defendant number one and other.
You produce the second order dated 2nd of March, tomorrow or day after tomorrow.
Yeah.
We'll take it up on that day.
Okay, day after.
Heard Mr. S.P. Roy, learned counsel for the appellant. This appeal under Order 43, Rule 1, within bracket R of the Code of Civil Procedure 1908 has been filed by the appellants impugning the order dated 16/2/2026 passed in Ms. J case number 20/2026 in connection with title suit number 11/2026 by the Court of Learned Civil Judge Senior Division Morigao, whereby the trial court declined to grant ex parte ad interim injunction at the first instance and issued notice to the respondents. It also appears that the next date of the case was fixed on 2nd of March. Stop. Learned counsel for the appellant has submitted that on 2nd of March, the notice issued to the respondents had returned after due service. However, the trial court did not consider the prayer for grant of temporary injunction even after that and fixed the case. When is the next date?
On 24th of
Fixed
March.
the case on 24th of March. A pointed query was raised by this court as to what order was passed on 2nd of March 2026. Learned counsel for the appellant has submitted that the said order has not been uploaded in the e-court website. He, however, submits that one day time may be granted to him so that he can produce the certified copy of this said order. The prayer is allowed. Let this matter be listed day after tomorrow
Obliged.
on 13th of March.
Item 9.
May please, your lordship. My lord, this appeal is directed against the judgment and order dated 4/12/2025, passed in MSC case number 5.5/2010.
Your claim was dismissed or for enhancement?
Claim was not dismissed, but our grievance is that the main offending vehicle has been given clean sheet. The Maruti van has come in a rash and negligent manner and dashed to a motorcycle. Motorcycle then knocked the victim, my lord. But the Maruti van has been given clear, my lord, completely clean sheet. No liability has been imposed upon the Maruti van.
How much compensation was awarded?
Compensation has been given, my lord, 13,01,787.
Who is to pay?
Directed to pay, my lord, direction is given against the motor driver of the owner of the motor vehicle or motorcycle, my lord. But the Maruti van is the main offending vehicles. Maruti van came in a rash and negligent manner, dashed to the motorcycle, then motorcycle has knocked the person. Ultimately, full contributing negligence is on the Maruti van. The Maruti van has been given kill sheet.
But you are otherwise getting the compensation.
Well, I am getting, but why I should get, my lord, not from the actual offender, my lord. That is my grievance, my lord.
Actual offender
Is Maruti van.
and the motorcycle owner is not in a position to pay.
Yes, that is also reason, my lord. He is not in a position to pay, my lord.
heard Mr. A.R. Sigdar, learned counsel for the appellant. This appeal under section 173 of Motor Vehicles Act 1988 has been preferred by the appellant Miss Lucky Gaur, appellant/claimant Miss Lucky Gaur, impugning the judgment and order dated 4/12/2025 passed by the Motor Accident Claims Tribunal number 1, Kamrup Metro, in MAC case number 515 of 2021, whereby though the appellant was granted compensation of rupees how much?
13,01,787.
However, who is the respondent, owner of the motorcycle?
Respondent,
However,
respondent motorcycle.
respondent number 3,
Yes, ma'am.
respondent number 3 was directed to pay the compensation to the claimant. It is contended in the memo of appeal by the appellant that the driver of the
Maruti.
offending
Respondent number 2.
Maruti who is the driver of the vehicle?
Owner come driver.
Owner come driver of the Maruti van bearing registration number AS04N0370 was responsible for the accident. However, the tribunal has exonerated the driver of the said vehicle as well as the insurance company which had insured the aforesaid Maruti van. Stop. I have gone through the grounds stated in the memo of appeal and heard learned counsel for the appellant. Stop. This appeal is admitted. Issue notice to the respondents. The appellant shall take steps for issuance of notice to the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 21st of April. Let also the records of MAC case number 515/2021 be called for from the concerned tribunal. The registry shall take steps for requisitioning the aforesaid records. List accordingly.
Item 10.
Maybe, my lord. The appealing here the insurance company which is challenged the award passed by MSD Dhupri Lordship, passing in award dated 9/6/25 Lordship for an amount of rupees 26,80,200 Lordship. And here the Lordship we have for your Lordship challenging that award on the ground that the Lordship.
You are challenging the liability or quantum?
No, quantum Lordship. Only on quantum here. Here, what happened, Lordship? The notional income has been taken by the land tribunal as 12,000 per month, but no such income proof was submitted by the claimant side. And hypothetically, Lordship, arbitrary 12,000 was taken, and at that time, your Lordship, if you see the minimum wages, that it's a maximum 8,955 for an unskilled labor, Lordship. And as per the ASALSA guidelines, Lordship, it was to maximum 8,000, Lordship. So
a 12,000 was very
Heard,
expensive,
Mr.
Lordship. Again, Lordship.
We are admitting.
Yes, Lordship.
Heard Mr. P.J. Burman, learned counsel for the appellant. Also heard Mr. A.R. Agarwala, appearing for
Claimants 1, 2, 3, 4.
4 also.
Amita Bibi.
I think 4 is
Amita Bibi.
1 to 3,
1 to 3. 1 to 3 only.
appearing for respondent number 1 to 3 / claimants. This appeal under section 173 of Motor Vehicles Act 1988 has been preferred by the National Insurance Company Limited, impugning the judgment and order dated 9/6/2025, passed by the Motor Accident Claims Tribunal Dhubri in MAC case number 41/2018, whereby the appellant was directed to pay a compensation amount of rupees 26,80,200, along with an interest at the rate of 7% per annum to the claimant's respondents. Stop. The appellant is mainly aggrieved with the quantum of compensation awarded to the claimants. Stop. I have gone through the grounds stated in the memo of appeal and have considered the submissions made by learned counsel for the appellant. This appeal is admitted. Call for the records of MAC case number 41/2018 from the concerned tribunal. The registry to take steps for requisitioning the records. Issue notice to the respondents. Since Mr. A.R. Agarwala has appeared for respondent number 1, 2, and 3, no formal notice need to be issued to said respondent. However, the appellant shall furnish a requisite number of copies of memo of appeal along with the annexures to the learned counsel for the respondent number 1, 2, and 3.
Already, sir, because he was a caveat. He
He
already got.
Caveat copy I got, but extra copy I
Furnish extra. As regards the respondent number 4 and 5, the appellant shall take fresh steps for issuance of notice upon the said respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 22nd of April.
2nd of April.
22nd.
22nd. But there is a stay also, Lordship. Stay application number 737.
You pay 50%.
Lordship.
Lordship, claimant
7.
number 1 can be allowed to withdraw. Lordship.
Why only claimant number 1?
All the
Why
other
only
claimants also. But they are the
Three
son and
claimants
daughters.
here also.
Son and daughters.
Heard Mr. P.J. Burman, learned counsel for the applicant. Also heard Mr. A.R. Agarwala, learned counsel for the respondent / claimants. This interlocutory application has been filed by the applicant insurance company in connection with MAC appeal number 103/2025, praying for stay of execution of the impugned judgment and award dated 9/6/2025, passed by the Motor Accident Claims Tribunal Dhubri in MAC case number 41/2018, whereby the applicant was directed to pay a compensation amount of rupees 26,80,200 along with an interest at the rate of 7% per annum. Learned counsel for the applicant has submitted that the applicant has impugned the aforesaid judgment and award in the connected MAC appeal number 103/2025. He further submits that said appeal has already been admitted and notices have been issued to the respondents. He also submits that the insurance company is agreeable to pay 50% of the awarded amount, to deposit 50% of the awarded amount as a condition for grant of stay of execution of the impugned judgment and award. Stop. Since the claimants, respondents are represented by their engaged counsel, and since the insurance company is ready to deposit 50% of the awarded amount, notice to other respondents is waived. Stop. This interlocutory application is allowed. The execution of the impugned judgment and order dated 9/6/2025 shall remain stayed during the pendency of the connected MAC appeal number 103/2023 25 2026, subject to deposit of 50% of the awarded amount by the insurance company before the registry of this court within 4 weeks, 6 weeks, within 6 weeks from the date of this order. In the event of such deposit being made by the insurance company, the registry shall disburse the same to the claimants, respondents, after proper verification. This
And bond subject.
after no, you are only a quantum, otherwise at least 50% you will have to pay. No bond is necessary.
Lordship, claimant number one, because she is the wife of the deceased lordship, and you are one, two, and son and daughter lordship. So
No, they may authorize that. I need not to write registry.
Yes,
Will
correct.
allow it.
on behalf of them, they
No, that order this court will not grant.
Yes.
The registry, if you bring proper authorization, registry will.
It's already been divided into.
Yes, this interlocutory application is accordingly disposed of.
Obliged.
caveat is that should be discharged.
The caveat stand discharged.
Item 11.
May it please your lordship. Your lordship, this appeal is purely on quantum of compensation, your lordship. Income of the deceased was not proved, your lordship.
Heard Ms. P. Thakur, learned counsel for the appellant. This appeal under section 173 of Motor Vehicles Act has been preferred by the SBI General Insurance Company Limited, impugning the judgment and award dated 16/6/2025, passed by the Motor Accident Claims Tribunal number 2, Kamrup Metro, in MAC case number 20/2024, whereby the present appellant was directed to pay a compensation amount of rupees 25,92,500, along with an interest at the rate of
9%.
9% per annum to the claimant respondents. Stop. The appellant is mainly aggrieved with the quantum of compensation awarded to the claimants. Stop. I have gone through the grounds stated in the memo of appeal, as well as considered the submissions made by learned counsel for the appellant. This appeal is admitted. Call for the records of MAC case number 20/2024 from the concerned tribunal. The registry shall take steps for requisitioning the aforesaid records. Let notice be issued to the respondents.
Respondent number 125, their names are already reflected, your lordship.
There was a delay condonation application.
No, your lordship, it has come up for the first time, but your lordship, in the meantime, the parties have arrived at compromise settlement of the case, your lordship. Lordship, I pray that this matter may be placed before the coming Lok Adalat, your lordship. 14/3/2020.
But let them appear. You have served notice on the other side,
No, Your Lordship, it has come up for the first time, but their names are reflected, Your Lordship.
wrongly reflected. Because we are issuing notice. If in the meanwhile you can contact the other side,
Yes, Your Lordship.
then you may make a mention. And then we will send it to Lok Adalat.
But it's as saying, Lordship, he was the conducting counsel. We had communicated. His name is reflected.
Who?
Mr. S. Singh, Your Lordship.
S?
S. Singh. His name is reflected, Your Lordship, in the cause list. And we have instructions from the company, Your Lordship, that the matter has already been settled, Your Lordship.
No, but we don't have anything on record. We are issuing notice. The issue notice to the respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 24th April.
Fixed the day after tomorrow, Your Lordship. In the meantime, we can talk to the council representing the claimants, Your Lordship. Then the matter can be placed before the Lok Adalat.
And if counsel for the appellant however submits that there is a development in this case in as much as the parties have arrived at an amicable settlement, and she submits that she will notify the learned counsel for the claimants respondents and request this matter to be listed again day after tomorrow. The prayer is allowed. List this matter again on 13th of March.
Okay.
Item 12.
May it please your Lordship. Lordship, herein we have filed the appeal because the court came to a clear finding that there was violation of policy condition, but still directed for pay and recovery, but not as per Nanjapal. And also, Lordship,
Not as per?
Nanjapal, Oriental versus Nanjapal. And also, Lordship, the accident took place on 5/2/2020 and the death was on 6/12/2022 after more than 2 years, and there was no post-mortem report. So those are main grounds, Lordship, along with other grounds.
What has been stated in Nanjapa's case?
That the insurance company will deposit, but that will not be released to the claimant till the owner gives a security. And that was in Shamanna also, except in Nanjapan judgment. In another case, I had submitted to Lordship.
Heard Ms. R.D. Majumdar, learned counsel for the appellant. This appeal under Section 173 of Motor Vehicles Act 1988 has been preferred by the Oriental Insurance Company Limited, impugning the judgment and award dated 1/12/2025 passed by the Motor Accident Claims Tribunal, Kacha Silchar, in MEC case number 421/2020, whereby the appellant was directed to pay a compensation amount of rupees 19,10,602 along with an interest of 9% per annum to the claimant's respondents, and thereafter recover the same from the owner of the offending vehicle. Stop. I have gone through the grounds stated in the memo of appeal and have considered the submissions made by learned counsel for the appellant. This appeal is admitted. Let the records of MEC case number 421/2020 be called for from the concerned Motor Accident Claims Tribunal. the registry shall take steps for requisitioning the records. Let the notice be issued to the respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 24th of April.
There is a I also, Lordship.
We are issuing notice.
We can deposit 50%, but release may not be allowed at this moment. Because death due to accident is also not true. We can deposit.
No, don't deposit now.
Okay.
We are issuing notice. Let them appear. Because is there any execution proceeding?
No.
No.
Then let it be in abeyance, Lordship.
Okay.
Uh,
Let them appear.
Yes, Lord. No issue. Highly obliged, Lordship.
Item 13. Item number 13.
None has appeared for the appellant on call. Let this matter be listed on 20th of March.
Item 14.
Not so bad, very fair to mention, but there's an analogous appeal. Last week, the appeal was appealed, and also stay was also granted. I think it's only fair to say, pass on this.
Already, it should be listed with another connected. There are 4 appeals, MAC appeal are pending.
We all tag together so they.
Heard Mr. R. Goswami, learned counsel for the appellant. Also heard Mr. A. Lal, learned counsel for the claimant respondent. This appeal under section 173. Also heard Mr. S.P. Sharma. You are also appearing for respondent number?
Respondent number 2, Lord.
Or S.P. Sharma appearing for. But there is no insurance company as. You are appearing for whom, Mr. Sharma?
Honor, Lord.
What on that?
Okay.
With RD Majumdar is
Respondent number
previous case
2.
With MS RD Majumdar is appeal.
Okay. This appeal under section 173 of Motor Vehicles Act 1988 has been preferred by the HDFC Argo General Insurance Company Limited, impugning the judgment and award dated 13/11/2025 passed by the Motor Accident Claims Tribunal, Kamrup Amingao in MEC case number 242/2019, whereby the appellant was directed to how much compensation was allowed? Why there are 5 appeals?
1451 million connected, one accident, Lord, 4%, 3% died, Lord.
So separate judgments were passed.
No, one judgment was passed.
Common judgment.
Sorry, Lord, separate judgment. was
Separate
passed.
judgment out of the same accident.
Out of the same.
Okay. Directed to pay and pay a compensation amount of rupees 19 lakh 70,266, along with an interest at the rate of, what was the rate of interest?
8%.
8%.
8% per annum to the claimant/respondent number 1. I have gone through the grounds stated in the memo of appeal and have heard learned counsel for the appellant. This appeal is admitted. Let the records of MEC case number 242/2019 be called for from the concerned tribunal. The registry to take steps for requisitioning the aforesaid records. since Mr. Lal has appeared for respondent number 1 and Mr. Sharma has appeared for respondent number 2, no formal notice need to be issued to the respondents. You have received the memo of appeal.
I will receive that.
I have not received. No, I'll leave.
However, the appellant is directed to furnish the copies of memo of appeal along with the annexures to the learned counsel for the respondents. It is submitted at bar that out of the same accident, there are 4 other motor accident MAC appeals pending in this court, namely
MSc appeal number 593 of 2026.
MAC appeal number
593 of 2026.
next
Next is 63 of 2026
63 of 20,
and 94 of 2026.
94 of 2026. Let this appeal be listed along with the aforementioned appeals on the next date. List accordingly.
The petition for stay also.
Stay. Stay, no objection.
Asif, the
50%.
previous 50% subject to Asif, execution of a suitable bond. That was the idea of that.
In this case,
It
the
is
liability is not in dispute, Lordship.
only quantum you are
Quantum,
discussing.
Lordship.
So why bond?
Why bond?
Not quantum, I have disputed the year also. Liability, mainly it's liability.
One,
Because as against 2%, the vehicle is found to be carrying 4%. It's a question of liability.
on the last occasion, I have given the judgment of my learned friend of Supreme Court. With the, even if agreed also, then the liability.
I heard Mr. R. Goswami, same council namely. Also, this application under Order 41 Rule 5 of the Code of Civil Procedure has been filed by the applicant insurance company praying for stay of execution of the impugned judgment and award dated 13/11/2025 passed by the Motor Accident Claims Tribunal, Amingau, Kamrup Amingau in MAC case number 242/2019. Stop. The learned, since the counsel for respondents have already appeared, no notice need to be issued in this case. Learned counsel for the appellant has submitted that the appellant insurance company is agreeable to deposit 50% of the awarded amount as a condition for grant of stay of execution of the impugned judgment and award. The learned counsel for the claimant does not raise any objection to the prayer made by the applicant. Hence, this interlocutory application is allowed. The judgment and award, the execution of judgment and award dated 13/11/2025 passed by the Motor Accident Claims Tribunal, Amingau in MAC case number 242/2019 shall remain stayed during the pendency of the connected MAC appeal number 108/2026, subject to deposit of 50% of the awarded amount by the applicant insurance company before the registry of this court within a period of 6 weeks from the date of this order. Stop. In the event of such deposit, the same shall be disbursed to the claimant/respondent number 1 by the registry after proper verification. This interlocutory application is accordingly disposed. No bond.
Executing a bond.
No bond.
Item 48 from supplementary list.
Please, your lordship. Senior is on lag, can it be taken up after some time, your lordship?
Oh, item number?
48, your lordship.
Okay. We'll take it after something.
Deeply, your lordship.
Order, item 15.
May I please, your lordship, it's an appeal for enhancement of the awarded amount. Lordship, the ID card in as per office note dated 9/3/2016. Lordship, the ID card in respect of the respondent number two not yet been received back to await service.
When have you taken steps?
Yes, sure.
When have you taken steps?
On 18
25 to, okay. What is your name?
J. Paul.
Heard Ms. J. Paul, learned counsel for the appellant. Also heard Mr. S.P. Sharma, learned counsel for the respondent.
Respondent number 1. Lordship.
Respondent number 1. Office note dated 9/3/2026 shows that the notice issued to respondent number 2 and 3. 3 you have taken steps.
No, actually, there is no three, actually, only two.
2 has not yet returned. Stop. The registry is directed to place the postal track consignment report of the notice issued to respondent number 2 by speed post before this court on the next date fixed. Let this matter be listed on 23rd of March.
Obliged.
Item 16.
May I please, also. Also, this appeal ought to have been in the admission column, also, because why it's listed in the order below, I don't know. This is part of 16, 116. No, 16, the money.
No, it ought to have been in hearing column.
Lordship, it was, but it's listed as orders.
So we'll fix it for hearing on any,
Short date will fix
you
your
choose a date.
Lordship.
What is the matter?
It's a first appeal
First
against a
appeal against
degree
the-
of specific performance.
Okay, so hearing would be required.
Lordship will take time.
Heard Mr. R.K. Bhuya, learned counsel for the appellant. Also heard Mr. B.D. Deka, learned counsel for the respondent. It appears that this appeal has been
31st March.
wrongly listed in orders column as the matter is all ready for hearing. Let this appeal be listed for hearing on
31st March.
31st March. Is it a hearing day?
It's a
hearing
Tuesday.
day.
Oh, 31st March.
Obliged.
Item 17.
May I please, your lordship? Your lordship.
Yes.
Continuation of delay petition, lordship, 99 days of delay.
99 days delay.
You're opposing?
No, your lordship. It may be condoned. It is a delay application 2023.
Heard Mr. S. Pegu, learned counsel for the applicant. Also heard Mr. D. Mandal, learned counsel for, who is respondent number 3?
He is the owner of the vehicle.
Owner of the vehicle.
You have not taken steps. What is to be done?
Your lordship,
Who has been directed to pay the amount?
insurance company.
Insurance company.
And your lordship, they will again take steps in the appeal.
In the appeal, yes, we are dispensing with.
Only 99 days delay.
Okay. क्या लिखा? Ms. Pegu. Also heard Mr. D. Mandal, learned counsel for respondent number 1/claimant. It appears from record that notice to respondent number 3 has not been served. However, considering the fact that this interlocutory application is only for condoning the delay in preferring the connected appeal, and the claimant is not opposing the condonation of delay, the notice to respondent number 3, respondent number
Three.
3 Who is two?
Who is the driver of the vehicle?
What happened to two? Notice to respondent number 2 and 3 are waived. Stop. This application under Section 5 of the Limitation Act 1963 has been filed by the insurance company, filed by the National Insurance Company Limited, praying for condonation of delay of 99 days in preferring the connected MAC appeal, whereby it has impugned the which order, which judgment you are impugning?
No, judgment can authorize. Paragraph of the
Which, what is the impugn order?
29 or 21/9/23.
Impugn the judgment and award,
25/23.
judgment and award dated 23,
5/23.
23/5, 2023, passed by the Motor Accident Claims Tribunal number 1, Kamrup Metro, Gauhati, in MAC case number 413/2017.
16.
2000?
16. 16.
2017.
17.
2017. Stop. I have gone through the grounds stated in the instant interlocutory application, showing reasons for delay in approaching this court in preferring the connected appeal within the prescribed period of limitation. Mr. D. Mandal, learned counsel for the claimant, has not opposed the prayer for condonation of delay. Considering the submission made by learned counsel, as well as considering the grounds stated in the instant application as sufficient grounds which prevented the applicant in approaching this court for filing the connected appeal as sufficient reasons, the period of the delay of 99 days in preferring the connected appeal is hereby condoned, and this interlocutory application is allowed. The registry is directed to register the connected MAC appeal and list the same for admission in the next week. Only date to be fixed by.
Oblige, Your Lordship.
Sorry, Lordship, I missed that item 13, Lordship.
Which one?
Actually, I was under the impression that my item is 16.
13. Record as
Your Lordship, we have basically come for on the quantum, Lordship, for enhancement.
heard Mr. R. Rahman, M. Ahmed, learned counsel for the appellant. This appeal under Section 173 of Motor Vehicles Act 1988 has been preferred by the appellants / claimants, impugning the judgment and award dated 1/2/2025, passed by the Additional District Judge within bracket FTC, Dorong. Dorong in MAC case number 57/2016. The appellants are mainly agreed with the quantum of compensation awarded to them by the impugned judgment. I have gone through the grounds stated in the memo of appeal and have considered the submissions made by learned counsel for the appellant. This appeal is admitted. Let the records of MAC case number 57/2016, MAC within bracket D, case number 57/2016, be called from the concerned tribunal. The registry to take steps for requisitioning the aforesaid record. Let also notice be issued to the respondent. The appellant shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on 24th April.
Your Lordship, in item number 17, while listing the appeal, my name may be reflected, otherwise.
In item number 17,
17.
item number 17, name of Mr. D. Mondal may be reflected in the cause list as engaged counsel for claimant's respondent henceforth.
So I is for condonation of delay of 90 days and service is already complete, Lordship. On the last occasion, we took steps upon responding.
How many days?
98, 98 days.
98. Mr. Patgiri,
98 days.
yes,
My lord, for 98 days.
you are opposing.
No, my lord.
Third, Mr. S.P. Sharma, learned counsel for the applicant. Also, Mr. K.R. Patgiri,
For the respondent number one.
learned counsel for respondent number 1. On
There are two respondent, Lordship. Respondent number 2, flag is of additional affidavit, paper publication.
you have learned counsel for the applicant has submitted that the notice on respondent number 2 has been served by substituted mode of publishing the said notice in newspaper, and to that effect, the applicant has also filed an additional affidavit annexing therewith the newspaper in which the notice was published. I have gone through the additional affidavit. The notice issued to respondent number 2 is accordingly deemed to be duly served. So this application under Section 5 of the Limitation Act has been filed by the applicant insurance company for condoning delay of 98 days in preferring the connected first appeal, whereby it has impugned the judgment and award dated 14/7/2023 passed by the learned commissioner, employees compensation Nagaon in case number NEC 54/2012. Learned counsel for the respondent number 1 has submitted that he has no objection if the delay of 98 days is condoned. Stop. I have gone through the grounds stated in the instant interlocutory application by the applicant showing the cause of delay. Stop. Considering the aforesaid grounds to be sufficient cause which prevented the applicant in approaching this court within the prescribed period of limitation, as well as considering the fact that the learned counsel for the claimant respondent has no objection to condoning such delay, comma, the delay of 98 days in preferring the connected appeal is hereby condoned, and this interlocutory application is allowed. The registry is directed to register the connected miscellaneous first appeal and list the same for admission in the next week.
Copy of the
This interlocutory application is accordingly disposed of. You may furnish the copy in advance.
Item 19.
May I please, Your Lordship? My lord, on the last order, an application was filed by the claimant side for release of 50% of the awarded amount, which was deposited before this honorable High Court, and we have no objection on that.
You are for the appellant?
Appellant.
Okay. And in appeal,
There are two more.
whether you have taken steps for?
Yes, yes. My lord,
You are appearing for Mr.
A.K. Gupta, first one, 1, 2, 3.
Okay.
on the last,
Heard Mr. C. Fukon,
yes, my
learned counsel for the appellant. Also heard Mr. What is your name?
R.K. Mohanto.
R.K. Mohanto, appearing for Mr. A.K. Gupta, learned counsel for respondent number 1, 2, 3. On perusal of the office note dated 5/3/2026, it appears that respondent number 4 and 5 have entered their appearance in this case by filing wakalatnama of their engaged counsel. Hence, the appearance of parties in this case is complete. Records I said. This appeal is for what? You are agreed by
agreed by the permit and the driving license of the
Okay.
of an inquiry.
Let the record of MAC case number 4/2017 be called for from the concerned tribunal. Registry to take steps for requisitioning the aforesaid records. List this matter after receipt of records on 22nd April.
My lord, there are 3 more IS. One was filed by the respondent, being the claimant side, and 3 other IS have been filed by the insurance company, by the appellant.
Why?
One for the stay, and as for the stay, Your Lordship, this Honorable High Court has directed us to pay 50% before considering the application. So we have paid this 50% before the registry. That application is yet to be disposed of. Then there are 2 more. One is for an application under Order 41 Rule 27 for taking additional evidence. And another one for the stay of the judgment.
Stay.
Stay, no. My lord, the condonation of delay was condoned. Delay was condoned. Only 2.
2 are
IS pending.
pending.
2 are pending.
We are disposing of this stay first. Item this 1672. This interlock heard Mr. C. Fukon, learned counsel for the applicant. Also heard Mr. R.K. Mohanto, Learned Counsel for respondent number 1, 2, and 3 / claimant. It appears that in the connected MAC appeal, the respondent number 4 and 5 have entered their appearance by engaging their counsel. Hence, in this interlocutory application also, no separate in this interlocutory application also, their appearance may be shown. Learned Counsel for the applicant has submitted that in the meanwhile, the applicant has already deposited 50% of, when have you deposited 50% of the awarded amount before the registry of this court?
11/11/2024.
On 11/11/2025.
24.
24, in pursuant to the directions of this court by order dated 5/8/2024. Learned Counsel for the Mr. Mohanto, any submission?
Lordship, no.
Learned Counsel for the claimant respondent does not have any objection. Considering the fact that the applicant insurance company has already deposited the 50% of awarded amount before the registry of this court, the execution of the impugned judgment and award dated 5/8/2019 passed by the Motor Accident Claims Tribunal, Lakhimpur, in MEC case number 4/2017 shall remain stayed during the pendency of the connected MAC appeal number 245/2024. This interlocutory application is accordingly disposed of. And will you file any objection in the Order 41, Rule 27
I
application?
have to take exception in this regard.
Stop. In 1678, I-1678, heard Mr. C. Fukon, also heard Mr. R. C. Fukon, Learned Counsel for the applicant, also heard Mr. R. K. Mohanta, Learned Counsel for respondent number 1, 2, and 3. Since in the connected MEC appeal, notice to respondent number connected MEC appeal, the respondent number 4 and 5 have already made their appearance. They shall be treated. No further notice is required to be sent to them in this interlocutory application. Learned Counsel for the respondent number 1, 2, and 3 has prayed for some time for taking necessary instructions as regards the application under Order 41, Rule 27 of the Code of Civil Procedure 1908, filed by the applicant, and if required, to file a written objection. The prayer is allowed. Let this matter be listed on 22nd of April.
Item 20.
May it please your lordship. Also, this is the case, I have filed this appeal. That this is a case of mistaken identity of the insurer, lordship. What has happened, lordship? In this case, there were 4 parties. Lordship. 2 parties, they are the army, lordship, the driver and the army itself, lordship. ZRIEF. The third is the owner of the, there's a collision between the scooter and the army vehicle. The entire pleading, allegation, affidavit, etc. is against the army vehicle. The learned member also will come to the finding, lordship, I'll take it, that it is the army vehicle, grief vehicle, which is liable for compensation. It's lordship liable for the accident, which had caused the accident. But in the final, when the award is given, the direction is given United India Insurance. United India Insurance was the insurer of the bike, which was hit by the A, and army vehicle has been held to be liable. Lordship, I'll just shortly take your lordship to this. This matter actually should go for hearing, lordship. I'll read out.
No,
this.
but this I is for what?
This I is for stay. This stay cannot be granted, lordship, because it's a wrong.
Stay of what?
You have the judgment award.
You have filed it.
It has to be an absolute stay because it's an entire mistake of fact. The army does not have any insurance, lordship. Army vehicles are never insured. They are self-insured.
No, on what ground the
Lordship, they have-
tribunal
Yes.
directed you?
I am the claimant and as well as respondent number 1 and 2 of this instant appeal, my lord. What happened? We have exhibited all the GR record. There is charge sheet
Charge sheet against whom?
against respondent number 3 in this case, my lord, who is the driver of the grief vehicle, and we all allegations are frustrated against that vehicle, grief vehicle, and there is no negligence on the part of the bike as well as the appellant.
Then stay has to be granted.
Objection subject to the 50% deposit because of I have filed.
Then why they should deposit 50% when they are not liable? That you are admitting.
I think this matter can be heard immediately.
Immediately, yes, my lord. I have no objection.
Immediately. Also, he'll get a very early relief, lordship.
Yes, my lord.
Okay. Heard Mr. R. Goswami, learned counsel for the applicant. Also heard Mr. B. R. Das, learned counsel for respondent number 1 and 2, as well as Mr. What is your name?
P.S. Patakal. TL4.
P.S. Bhattacharjee, learned counsel for respondent number 3 and 4. This interlocutory application under Order 41 Rule 5 of the Code of Civil Procedure has been filed by the applicant insurance company, praying for grant of stay of the execution of the impugned judgment and award dated 17/11/2023, passed by the Motor Accident Claims Tribunal, Singapore, in MAC case number 15/2022 within bracket D. Learned counsel for the applicant, Mr. R. Goswami, has submitted that in this case, the tribunal, in the impugned order, has categorically held that the accident was caused due to negligence of the driver of the grief vehicle bearing registration, driver of the vehicle bearing registration number 10C-20045 grief. However, the tribunal has, without any reasons, directed the present applicant, who was the insurer of the motorcycle involved in the accident, to pay the compensation amount. He submits that no Reason, what was the reason stated by the tribunal for directing you?
No reason, Lordship,
No
because
reason,
till the last moment, they are holding the, tribunal is holding the
He
enemy
submits
vehicle
that
responsible.
no reasons have been ascribed by the tribunal for directing the present applicant to pay the compensation. Hence, the present applicant has filed the connected appeal, MAC appeal number 77/2024, impugning the aforesaid judgment and award. He submits that since there is no material on record which could have made the present applicant liable to pay compensation to the claimants, the execution of the impugned judgment and award is required to be stayed during the pendency of the connected MAC appeal number 77/2024. Stop. On the other hand, learned counsel for the claimant respondent, Mr. B.R. Das, has also fairly submitted that the charge sheet was also laid against the driver of the grief vehicle, and there is no material, and the tribunal has not justified, had not given any justification for imposing the liability to pay the compensation by the present applicant. Stop. Considering the submissions made by learned counsel for both sides, and considering the fact that prima facie it appears that the liability to pay compensation was imposed on the present applicant without showing any reason for the same in the impugned judgment. The execution of the impugned judgment is required to be stayed during the pendency of the connected MAC appeal. Accordingly, same is done. This interlocutory application is accordingly disposed of. Appeal to heard Mr. R. Goswami, learned counsel for the appellant. Also heard Mr. B. R. Das, learned counsel for respondent number 1 and 2, as well as Mr. P. S. Bhattacharya, learned counsel for respondent number 3 and 4. This appeal is ready for hearing. Hence, let this matter be listed for hearing. 28th of April.
21.
May I please your lordship?
Yes.
Lordship, kindly see the last order dated 16/2/2026, lordship. Lordship, last dated, we prayed to take appropriate step for substitute the respondent number 2. Lordship, but we don't have the legal's name, lordship.
Then then the appeal will be abated against respondent number 2.
Yes, lordship.
Who is respondent number 2?
Driver of the vehicle, lordship.
When he died?
As per office noted, lordship, 2 years ago, lordship.
Then it has already abated.
Yes, lordship.
Then it will proceed against other respondents.
Yes, lordship.
If you don't take steps, the appeal would abate against the said respondent.
Yes, lordship. Lordship, this appeal is for enhancement, lordship. And
Enhancement?
yes, lordship.
Then driver may not be required also.
Yes, lordship.
Heard, Mr. What is your name?
AU Ahmed, Lordship.
Heard, Mr. A.U. Ahmed, learned counsel for the appellant. Also heard Ms. P. Bothakur, appearing for respondent number
Respondent number 3, Your Lordship.
3. It appears that notice issued to respondent number 1 has already been duly served. Stop. However, as regards respondent number 2, learned counsel for the appellant submits that the respondent number 2, who is the driver of the offending vehicle, has died 2 years back, and the appellant does not have the information regarding legal heirs of the said respondent. Hence, they are unable to take steps for substituting the legal heirs of the said respondent. Stop. Stop. Considering the submissions made by learned counsel for the appellant, it appears that if the respondent number 2 has expired 2 years back, the appeal has already abated against him by operation of law. It also appears that in this appeal, the appellant is aggrieved mainly with the quantum of the compensation awarded to him. Hence, the presence of respondent number 2, who was the driver of the offending vehicle, may not be necessary in considering the instant appeal. Hence, this appeal shall proceed in its normal course. Records I see. It appears from record that this appeal is ready for hearing. Let this matter appeal be listed for hearing May, 5th of May.
Lordship, highly obliged. Lordship.
Obliged, Your Lordship.
Item 22.
May I please, Lordship? The service report is still awaited, Lordship, to respondent number 1 and 2. But subsequently, this respondent number 1 and 2 file another appeal, Lordship, MSC appeal, for shifting the liabilities from respondent number 1 and 2 to respondent number 3, the insurance. So let both the matter will take together, Lordship.
Yes.
That
Heard.
number is 345/2025.
Heard.
Mr.
Mr. What is your name?
MK Neo.
M.K. Neog, learned counsel for the appellant. Also heard Miss L. Sharma, learned counsel for respondent number 3.
Insurance.
It appears from office note dated 6/26/2026 that the notice issued to respondent number 1 and 2 have not yet returned. Stop. Learned counsel for the appellant has submitted that in the meanwhile, the respondent number 1 and 2 have preferred another appeal against the judgment impugned in this appeal, and the said appeal has been registered as MAC appeal number 345/2025. He prays for listing this appeal along with the aforesaid appeal. The prayer is allowed. Registry to list this MAC appeal along with MAC appeal number 345/25 on the next date. Let this matter be listed. 26th of March.
Item 24.
Please, my lord. This is in orders today,
Clement,
and we have already deposited 50% of the awarded amount, your lordship. That is 22,31,857 euros. And here, respondent number 1, 2 claimants just appeared, and respondent number 4, Reliance Range, has also appeared. Name has been shown. And respondent number 3 is the owner and driver.
Respondent number 3, what has happened?
It's not returned yet, Lordship, it in service, Lordship. And they are not required, Lordship, because it's only on quantum. We are just disputing that salary certificate here, the admissibility of the salary certificate.
Which I am appearing for 1 and 2.
You are appearing for 3.
I am appearing for 4, my.
Four.
number 4.
Reliance. Owner driver may be struck off loss. That's for number 3.
So we will file IA for withdrawal of.
So we have already deposited. There is a stay petition also.
Heard Mr. P.J. Burman, learned counsel for the appellant. Also heard Mr. R.K. Mahanta, learned counsel for respondent number 1 and 3, as well as Ms. L. Sharma.
1 and 2.
1 and 2, as well as Ms. L. Sharma, learned counsel for respondent number 4. It appears from office note that though the notice to respondent number 3 was issued long back, no service report has been received. Learned counsel for the appellant has submitted that since the appellant has preferred this appeal, mainly agreed with the quantum of compensation, the presence of respondent number 3 may not be required. Hence, notice to respondent number 3 is hereby waived. Stop. Record I say. The records of the MSc appeal has MSc case number 13/2022 has already been received. Hence, this appeal is ready for hearing. List this appeal for hearing on
So there is a stay pending, 409 of 20.
stay application.
We have already deposited 50%.
No, it is disposed of. Stay has been disposed of
Lodge.
on 12/3/2025.
I
We will
apologize.
file IA for withdrawal of.
You may file.
Yes.
Oblige, Lodge.
Item 25.
May this Lordship. As per office note dated 22/2026. Service on respondent number 1 and 3 is complete. As per respondent 2, no one is present. He may be allowed to take fresh steps on respondent number 2.
Respondent number 2, what?
We may be allowed to take fresh steps.
Fresh steps, okay. Heard Mr. What is the name? A.
Yeah.
Acharya, learned counsel for the appellant. Also heard Mr. B. Borua, appearing for respondent number 1. And how many respondents are there?
3, Lordship.
Who is appearing for 2?
The 2 we are praying for. We may be allowed to take fresh step on 2, Lordship.
Only 2 respondents are there.
No, 3, Lordship.
Who is appearing for 3?
No one is appearing for 3, but service is complete, Lordship. As per office note 22.
It appears from record that notice to respondent number 3 has already been duly served. However, as regards respondent number 2, the notice have returned without service. The learned counsel for the appellant has prayed for allowing the appellant to take fresh steps for issuance of notice to respondent number 3.
2, Lordship.
prayer is allowed. The appellant shall take steps for issuance of notice upon respondent number 3 by speed post as well as by usual mode.
Lordship, as exponent number 2.
Respondent number 2 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 6th of April.
Item 27.
May it please your lord. Well, I am the claimant respondent, my lord. I have filed this IA for withdrawal of 50% award and deposited by the appellant company.
Now, what is the status in main appeal?
Chip service is complete. We have filed our additional affidavit showing newspaper publication for respondent number 3, that is flag A, Lordship.
What miss in main appeal, separate order. Third, Miss R. D. Majumdar, learned counsel for the appellant. Also heard Mr. K.K. Day, appearing for respondent number 1 and 2. The appellant has filed an additional affidavit.
Flag A, Lordship.
Additional affidavit regarding compliance of direction to take steps for issuance of notice upon respondent number 3 by substituted mode in newspaper publication. The newspaper in which the notice was published has also been annexed along with the additional affidavit.
Homia Proceeding.
Stop. I have gone through the same. It appears that the date of appearance in the said notice has been mentioned as 28 January 2026. Hence, the notice issued to respondent number 3 is held to be duly served. Only 3 respondents are there.
Yes, Lordship. So you can go for final hearing, Lordship, instead of the any day, Lordship, next week also.
The what is the ground for
That pay and recovery. Most of my cases are that only. I am branded pay and recovery. Let it go for hearing, Lordship. I do not mind. Next week also, I think then, so a clear order is there, then Lordship. Instead of now taking 50% and 100% take up, sir.
No, let them take 50%.
No, Lordship, then it will be delayed. That itself creates delay. Lordship, next week
No
hearing.
question of delay, my lord. If your lordship fix that case, then it will be hard if it reaches.
Okay.
It reaches, Lordship. Yesterday also so many cases were heard.
It appears that this case is ready for hearing. Hence, let this matter be listed for hearing.
On
12th
any day they want, Lordship.
12th of May. 12th of May. List accordingly. Then we will take up the IA.
Yes,
Will not take up the IA today.
My lord, my lord, it's a death case, my lord. Clement is the wife and son, my lord. Otherwise, my lord, they are in financial difficulties, my lord. The lordship considered, my lord, they have not.
12th May, say.
They have not received a single farthing, my lord.
Good details. April.
28th April. In
April ki bata date. 28.
Ayat likhibo. This interlocutory application has been filed by the claimant respondents for issuance of a direction to the registry for disbursing the 50% of the awarded amount deposited by
May I
the
submit one thing, madam? Simple thing, madam. The order was passed considering the Supreme Court judgment. 2 judgments were considered before directing pay and recovery. And my lord, they have not adduced evidence. They have adduced evidence of an investigator. how the investigator can give evidence without evidence of the
That will
company
be in the
itself, my
final
lord?
hearing, Lordship, not
My lord,
today.
My
Lordship.
lord, only on that point, my lord, the appeal has been filed.
No, if they take 50% now with an undertaking,
Oh, yeah, my
Lordship,
lord, my lord, I shall give undertaking, my lord.
Oriental versus Nanjappan is very clear. Taking an our High Court Sonali Kolita judgment is passed by Justice Surana.
what Oriental versus Tanjapan has stated.
Lordship, I do not.
We'll take it up on the next date. Let her bring the judgments. You also come prepared.
Yes.
Well, in the meantime, no guarantee, my lord, that on that date, the case.
No.
will be heard, my lord.
Mention it,
Election.
My-
No,
Dispersing the 50% level.
stop. It appears that since the connected MAC appeal is, that is MAC appeal number 167/2025 is listed for final hearing on 28th of April. Let this
My lord,
matter.
I shall pray for an early date, my lord, before 28th April.
Video okay, kunai, I'll do the hearing. If necessary, I can mention it for 2 o'clock or something like that.
Amar, list mote dibo. Let it be on 28th of April. 28th of April. This
26th, no, hoboni.
26th of April. Hearing.
Sunday. So, তার আগতে substitute, huh?
23rd of April. It is clarified here that if this court fails to take up the MAC appeal, connected MAC appeal on the next date fixed, then the applicant may press for this interlocutory application on the said date,
Yes, sir. No issue.
list accordingly.
Tell you, please.
Item 28.
28, Lordship, here the service is complete. Lordship will peruse office note dated 7/3/26. For R1, it is received by brother-in-law. For R2, 3, 4 received by father-in-law. And flag A, Lordship. And even seven.
Have a respondent number 1 to 4.
Oh, yeah.
This
Wow.
climax, Lordship.
How many respondents are there?
Total 630.
Total 7, Lordship.
5 and 6, Mr. Chaudhary. So appearance is complete.
Appearance is complete, my lord.
It can
Record
go
has
for
already-
final hearing,
for
Lordship.
Hearing, my lord. The date may be fixed kindly, Lordship. The
Heard Ms. R.D. Majumdar, learned counsel for the appellant. Also heard Mr. R. Ali, learned counsel for respondent number 1 to 4, as well as Mr. G. Chaudhary, appearing for respondent number 5 and 6, and Ms. P. Bothakur, appearing for respondent number 7. The appearance of parties in this appeal is complete. It also appears that the records of the concerned MAC case have also been received. Hence, this matter is ready for hearing. List this matter for
immediately after review, Lordship.
12th of May. 12th May.
April, Lordship. So respondent number 2 and 3 are college going student, and respondent number 4 senior citizen, the mother of the disease.
No, we are fixing the matter according to our board. If we fix more than we can take, it is of no use. 12th May, we will be in a position to hear it.
Hidden manner, what difference?
Item 29.
29, Lordship,
Well-
but affidavit in opposition is not yet tagged, Lordship.
29 is for,
They file a IA.
May I please, sir? May I beg your lordship indulgence? My lordship may kindly say that I.
no, before going to IA, what has happened in the main appeal?
Main appeal, Lordship, LCR received. And for respondent number 2 and 3, the service report was not yet received. That is office note dated 5/2/26. After that, office note, they have not given, I suppose, Lordship. Only office note is, our affidavit is not tagged with it. We have filed our objection, Lordship.
No, in the appeal, whether appearance is complete.
No, Lordship. 2 and 3, Lordship. They are owner and driver, Lordship.
When have you taken steps? Okay,
Steps,
okay,
Lordship,
okay.
we had taken.
Heard Miss R.D. Majumdar, learned counsel for the appellant, appellate likhibo. Also heard Mr. R. Goswami, appearing for respondent number,
Respondent number 1.
respondent number 1. On perusal of the office note, it appears that notice issued to respondent number 2 and 3 have not notice issued to respondent number 3 has been served on who is respondent number 3?
He's the driver, I suppose, Lordship. I'm just looking. Yes, driver.
What is the name?
Nicholas Kaiso.
Yes,
No.
has been served on respondent number 3. Hence, same is held to be duly served. However, notice issued to respondent number 2 has not been returned. The registry is directed to place the postal track consignment report of notice issued to respondent number 2 by speed post, before this court on the next date fixed. Let this matter be listed on
May please,
25
Your Lord.
March. आए तो जो
Monday, delay.
25 March. Yes,
I
what?
beg your lordship indulgence, may kindly be looked into I 57 of 2026.
Our Lordship affidavit in
triple man.
opposition is not.
Not in this manner. One by one, let her submit.
I is my I.
Okay, yes.
Somebody
I-
submit.
Oh, your lordship, I'm a crippled man. I have 50% disability. I have appeared before this honorable court. I'm surviving for the life. And so 50% may kindly be released. And they've, I do not know what objection they should have because this 50% is in the custody of the court.
This I is for release of
Release of
50%.
50%. I'm dying. I'm a crippled man. I'm a 50% disability do I have? How can I survive in a single day? It's just
Yes, yes.
breaking point.
We have filed our affidavit in opposition. That is not on record, Lordship. As soon as it comes on record, because we are also talking about fraud, Lordship. Lordship, I've mentioned in my, the driver as per their own exhibited document, Lordship.
Where is the stay? Stay,
May I please, your
He
lordship, it
is
may be in the
2829, Lordship.
wait, 29. It has been disposed of.
disposal.
Yes, Lordship.
Okay.
It's a point of my
Then
survival.
let her, we'll give a short date.
Very
Let,
sure that because every.
let the-
In fact, I don't think there should be any point because it's a given for my survival. But
Heard.
very sure that may be given because every day is a breaking point and every day is announced to.
heard
you.
Mr. R. Goswami, learned counsel for the applicant slash claimant. Also heard Miss R.D. Majumdar, learned counsel for the opposite party slash insurance company, who submits that the insurance company has filed an affidavit in objection,
Position.
affidavit in opposition against the prayer made by the applicant for release of 50% of awarded amount to him. However, the said affidavit is not placed with the instant interlocutory application. She prays for calling the same. Stop registry is directed to place the affidavit in opposition filed by the insurance company along with this interlocutory application on the next date fixed. Place this
Your
matter.
lordship, it may kindly be fixed for the next week. It's
When?
very important.
25-3, it is
Yes.
fixed.
25-3.
Yes. 25.
Is it three?
25-3.
Three.
March itself.
March itself. Obliged.
Ali obliged.
Item number.
May please, your lordship.
Yes.
My lord, I was filed for continuing delay, my lord, for 108 days, my lord. Perhaps they have filed objection, my lord.
Yes, Lordship, we have
You're
filed the
objecting.
objection, but it's not on record, Your Lordship. The record may kindly be called for. And the matter may be listed anytime next week as per the convenience.
I am for respondent number 1 and 2 claimants. I have no objection so far as delay is concerned. Lordship.
Heard Mr. T. Kolita, learned counsel for the applicant. Also heard Mr. M. Talukdar, learned counsel for the respondent number 1 and 2, who submits that the respondent number 1 and 2 / claimant do not have any objection if the delay in preferring the connected appeal is condoned. However, on the other hand, Ms. A. Biani, learned counsel for respondent number 4, has submitted that respondent number 4 has filed a written objection against the prayer for condonation of delay made by the applicant, however, same is not yet placed on record. She therefore prays for calling the aforesaid written objection. The prayer is allowed. Registry is directed to place the written objection filed by respondent number 4 along with this interlocutory application on the next date fixed.
18th, Lordship. 18, my lord. 18.
18. Let this matter be listed on 18th of March.
Published.
Item 32.
No, please, Your Lordship, my lord, in this case, my lord, we had to file ABTV objection, my lord, but we are adding for some documents. my lord.
Delay, so Lordship, we have filed one IA for condonation of delay, Lordship. And on that
Filing the
condition-
review petition.
Yes, Lordship, review petition of your Lordship, sir, that was ex parte, Lordship. Review order was passed ex parte, Lordship. So we have filed one IA for condonation, and in that case, they prayed for filing objection on last occasion. So today also they need some more time.
Some more time is required, my lord. We are waiting for some documents from the lawyer.
Heard Ms. R. Chaudhary, learned counsel for the applicant. Also heard Mr. M.H. Talukdar, learned counsel for the respondent, who prays for some more time for filing objection against the application for condonation of delay filed by the applicant. When will you file? The prayer,
It can be on 9th of April, Lordship.
the prayer is allowed. Let this matter be listed on 9th of April.
I'm deeply obliged.
Item 33 and 34.
My lord, this is a review petition, my lord.
We are issuing notice.
Hello, please.
This heard Mr. B.R.
Yeah.
Das, learned counsel for the applicant. This application it is under what provision? It cannot be under 226. You rectify the cause title of your application. Otherwise, it will be dismissed. Heard Mr. B.R. Das, learned counsel for the applicant, who seeks some time to rectify unintentional typographical error which has crept in the cause title of the instant review application. The prayer is allowed. The applicant is allowed to file a rectified cause title on the next date fix. List this matter when?
28 April.
23?
28 April.
28th
April.
April.
Same order may be passed, my lord, item number 35.
35 so. Yes, same order. Same order.
Item 37.
May I please, my lord?
Yes.
My lord, an IA has been filed by the applicant for correction of error of the order dated 23/7/2025. Passed by this honorable court in AB number 1722/25.
What error? So why so long,
Yes, my lord.
after so long time you have approached?
The lawsuit is true.
What is the error?
Unintentional delay on the part of the applicant.
What is the error?
My lord, the error is, the order is annexed here with it. My lord, page number 9, para 11.
Yes.
Here in the last line, my lord, the PRC case number is 43/2025, which is actually incorrect, my lord. And it has been recorded as PRC case number 42/2025.
From where we will come to know the actual PRC case?
My lord, while the applicant complying this order in the further proceeding, my lord, then he could come to the notice that the PRC is 43/2025, my lord. Later on, he noticed this error, my lord.
So this is not the error of the court, it is your error.
It's my lord.
You have mentioned.
My lord, I agree with.
Now, where is the material to show to the court that the PRC case number is actually 43? Apart from your averments which you have made in the application, is there any other material to show?
So far as this concerned, my lord, I haven't.
Certified copy of the
We
order?
have summon notice, my lord. However, this has not been annexed here with me in the I.
Annex it by tomorrow, we'll rectify.
My lord.
Because on the basis of your averment, it was mentioned as 42. Now, again, on the basis of your averment, if we change it, tomorrow again you may come that I was wrong. So give something so that court may believe you.
I'll make an announcement, my lord.
Heard, Mr. PK. What is your name?
H. Cooley, my lord.
H. Cooley, Learned Counsel for the applicant. This interlocutory application has been filed by the petitioner in connection with AB case number 1722/2022-2025, wherein according to petitioner, the PRC number mentioned in paragraph number 11 of the order dated order dated 23/7/25 has been wrongly mentioned as PRC case number 42/2025 instead of PRC case number 43/2025. Learned Counsel for the petitioner submits that the petitioner was not aware about the correct PRC number, which he came to know only after receipt of summons from the trial court. However, no copy of summons have been annexed along with this interlocutory application. Stop. Learned Counsel for the applicant prays for allowing the applicant to file an additional affidavit to bring on record the necessary documents, including the summons received by him, from which the correct case number may be ascertained. The prayer is allowed. When? By Monday. Let this case be listed again on 16th of March.
My lord, can it be tomorrow?
Tomorrow, will you be able? Okay, tomorrow. Let it be day after tomorrow,
After tomorrow, my lord.
13th of March.
Obliged, my lord. Item 39.
May please your lordship. Also, there are three respondents here. In service on, none of them is complete lordship. But lordship, I have an urgency, so may I be allowed to take steps by dusty service lordship on all three. They are all in the same area, Baska district. Lordship, I have received a execution notice also on this. And that is urgency.
Okay. Heard Mr. R. Goswami, learned counsel for the, this is delay condonation.
Delay condonation. This is a condonable delay lordship, 33 days.
Heard Mr. R. Goswami, learned counsel for the applicant. On perusal of the office note dated 9/3/2026, it appears that notice issued to respondent number 2 and 3 have returned without service with postal endorsement. Stop. Whereas notice issued to respondent number 1 has not yet returned. Stop. Learned counsel for the applicant submits that considering the urgency of the case, as an execution case has also been filed, comma, the applicant may be allowed to take steps for issuance of notice by dusty mode. The prayer is allowed. The applicant shall take steps for issuance of notice on respondent number 1, 2, and 3 by dusty mode within 7 days of date of this order, returnable on 1st of April.
Also, if possible, earlier than that.
Early,
After 3 weeks, lordship, immediately. A date given.
27th
I'll
of
try to complete the entire exercise within the
27th of March.
27.
If the applicant is able to serve the notice by dusty mode, he shall submit an affidavit of in compliance thereto on the next date fixed, list accordingly.
I have a humble prayer also. In view of this notice, also can some temporary protection be?
Hmm.
I cannot make a prayer as of right, Lordship. I'm only appealing to your Lordship. Discretionary power.
27th আসেন
It's a
27
discretionary year, Lordship.
তারা বলতেও
I'm just, this humble prayer on the.
23rd, we are preponing the date. Instead of 27th March, let it be 23rd.
I want to make a prayer in that case. 13th is the date for execution. This is the year, Lordship. Just till that date, Lordship. If the delay is not condoned, this will go. Only till that date.
No, you have filed any,
I filed an application for stay also. There's an interim protection only, till that time.
$60 days.
On 13/3/2026. It's because of.
No, if on 13/3 they issue any coercive measure, then you approach. Then
We'll
we,
make a prayer before them that this matter is pending.
yes, you can approach before the Baki Jai
I'll
office.
definitely do that.
If still they proceed with any coercive measure, you may approach this court by mentioning.
Obliged, so deeply obliged.
Item 41.
May I please, your lordship. Hello. Our MSc appeal is barred by limitation. That's why, my lord, we have filed IA civil norm.
How much delay is there?
19 days. It's barred by 19 days.
We are issuing notice. Heard Mr. J. Mullah, learned counsel for the applicant. This application under Section 5 of the Limitation Act has been filed by the applicants, praying for condoning the delay of 19 days in preferring the connected MAC appeal, whereby the appellants have impugned the judgment and the claim was dismissed.
No, my lord.
Enhancement,
For enhancement.
where the judgment dated 20/12/2024 passed in MSC case number 2102/2016. Issue notice to the respondents. The applicant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 7th of April.
Maksud.
Item 42.
May this is your lordship. This is listed for the first time. There is a delay of 164 days in filing the.
Issuing notice.
Yes, lordship.
Heard Mr. R.D. Majumdar, learned counsel for the applicant. This interlocutory application has been filed by the applicant insurance company under Section 5 of the Limitation Act, praying for condoning the delay of 164 days in preferring the connected appeal, whereby judgment and order dated 21/2/2023 passed by the learned commissioner, employees compensation, Nagaon in NEC within bracket WC 51/2006 has been impugned. Issue notice to the respondents. The applicant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 7th of April.
Item 43.
43 is also first time lordship. There is a delay of 73 days.
43, same order. This is also again the employees compensation,
Yes.
same order. Date same.
Highly obliged.
Item 44.
44 is MSc lordship. There is a delay of 15 days.
Mr. R.D. Majumdar, learned counsel for the applicant. This interlocutory application has been filed by the New India Insurance Company Limited, praying for condoning the delay of 15 days in preferring the connected MAC appeal, whereby the judgment and award dated 13/6/2025 passed by the Motor Accident Claims Tribunal number 2, Kamrup Metro at Gauhati in MSC case number 1843/2023 has been impugned. Issue notice to the respondents. The applicant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 8th of April.
Highly obliged.
Item 45.
May please be my lord, but the condoned delay petition by the claimant. First time lordship, so notice may come.
Heard Mr. A.R. Agarwala. Issue notice, same order, 8th of April.
Extend both ways.
Both ways.
Please, lordship. Lordship, in preferring the MSc appeal, there is a delay of 374 days. And so there will be a final interlocutory application.
Heard Ms. P. Borwa, learned counsel for the applicant. This application under Section 5 of the Limitation Act 1964 has been preferred by the applicant Farooq Hussain, praying for condoning the delay of 374 days in preferring the connected MAC appeal, whereby the judgment dated 21/10/2024 passed by the Motor Accident Claims Tribunal, Nagaon, in MAC case number 333/2021 has been impugned. Issue notice to the respondents. The applicant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 9th of April.
Item 47.
Lordship, this is also a delay petition, employees compensation, and the delay is of 210 days.
Employees compensation ka order, same order. Ms. Hadi Majumdar. Returnable on 9th of April.
Obliged.
Item 48.
May I lordship, please? To file this appeal, my lord. My learned friend also appears on the caveat. I'm on caveat. So I'm happy, my lord, that we may, if lordship is kind enough to, we may also dispose this, my lord. That appeal. But he is here. The short question is arising in this appeal, my lord. You have filed this appeal, my lord, against an injunction order whereby a status quo order was passed by the learned civil judge Dibrugarh. And my construction over the suit land that was now halted, you know. That's the urgency of this entire matter. Now, may I lordship, I've just placed on some admitted facts, madam. This respondent number.
Both the respondents have appeared.
No, this, the respondent number 2 is my vendor.
Okay.
One of the vendor, and he's my vendor.
I'm the plaintiff.
He is the plaintiff.
Okay.
So the respondent numbers 1 and 2 stands are altogether in the written statement and the written objection are supportive of each other. No conflict of interest. Now, what I would like to place, my lord, that some admitted facts is the plaintiff has filed a suit for specific performance of a contract that dated 11th of August 2015. It's a registered agreement. And he has filed a suit in the year 2024. Number 1. Number 2, my lord, the suit, the entire land under the DA that was including the suit land that was purchased by us by a registered sale deed on 7th/1/2025, 7th of January 2025.
The contract was between the respondent number 1 and 2.
No.
Yes.
Respondent 1 and 2.
1 and 2. Okay.
Correct.
Who sold the land to you?
The 2 along with the other co-owners, because he is not the only sole co-owner.
Okay.
I will come to them. Now, on 7th January 2024, 1 Kattha 0.84 lucha, that includes the suit land, that's 10 lucha. Suit land is 10 lucha, my lord. That was conveyed to us by registered sale deed at a sale consideration of rupees 26,75,000. Thereafter, the land was mutated in our favor. We have started the boundary wall construction completed, and we have started, my lord, the ground plus 2, ground G+2 building. And we have already constructed both the roofs. That is admitted part, my lord. They have filed all the photographs, etc. before the trial court also. That's not disputed. So we have already constructed, and construction is going. Now, by the order of 24th February 2026 is the impugnment before this honorable court. The London judge, the London civil judge has passed an order of status by an impugned order. May I draw the attention of the first, my lord, that agreement?
Whether Miss case has been disposed of or?
Yes, absolutely.
It has-
Finally disposed of. Initially, notice was issued,
And in fact, my lord, what happened, this plaintiff has filed a suit first in 2024 before the junior division, civil judge, impleading the respondent number 2 alone. Now, while that suit was pending, it has came to their knowledge that the land was already been sold out by all the legal layers, including the respondent number 2.
Okay.
Then they have filed an application for impleadment of our client and also amendment the plate. Now, when that amendment and impleadment was allowed, they filed the amendment plain. Then the learned court noticed that the valuation is 20 lakhs, 26 lakhs 75,000. That's the valuation of the sale deed. So therefore, the learned court below, civil judge, returned the plain under order 7 rule 10. Under order 7 rule 10, they returned the plain to, and thereafter they filed the suit before the civil judge senior division. Thereby this suit came and the miscase came. Now, lordship is the admitted position is that
Suit for specific purpose.
specific performance also for cancellation of our sale deed,
As well as.
mutation, etc., etc.
Okay.
Our sale deed also they paid for a cancellation, though they having a only claim over the 10 acres of land. Now the important question involved in this cause, whether the specific suit is maintainable, performance suit. Because they are they approached the court after 8 years, 5 months admitted. Therefore, I would like to request this honorable court, kindly see the cause of action, my lord, because the first cause of action they said 11.8, that is the registration of the sale agreement. Then straightway they comes to January 2024, the second cause of action. The lordship kindly have a look of the copy of the plaint, para 35, page 41. Absolutely barred by limitation, my lord. Though his arguable point is a mixed question of law and fact, but now the Supreme Court has settled, my lord, that if it is admitted position, the limitation, then it cannot be a mixed question of law and fact.
Para?
Para 35, page 41. What you will comes to page 42. Top. 41 it starts below para 35.
Yes.
Yes. Lordship will kindly have a note that on 11th day of August 2015, the date of execution and registration of the agreement for sale in respect to land. This is the first cause of action. Then the second is 14/8/2015, when the plaintiff obtained the original copy of the agreement for sale. Now straightway comes to, my lord, the third cause of action is since January 2024, when the plaintiff repeatedly approves the defendant 1 with respect to either to obtain the sale and purchase permission as agreed by him in the aforesaid agreement or furnish the documents to the plaintiff for the purpose of obtaining the sale and the purchase permission. So this is absolutely not much, not less, my lord, 8 years, 5 months.
What is the limitation?
Limitation is 3 years, my lord. From either is if it is in the agreement, if it is the time is fixed, or otherwise, if no time is fixed, then from the time of the refusal. Now you approach, you slept over 8 years, and you come after 8 years, 5 months, and ask me to obtain the sale permission. Because in the sale agreement, it is in clause 6 that there is a provision that the agreement to the sale date will be executed after obtaining the sale permission as soon as possible. No, lordship is no prudent man can say that as soon as possible means that it is 8 years, 5 months after.
No, let us go through the
agreement
limitation provision.
Yes, say Article 54, my lord. Article 50.
Limitation.
If time is fixed, my lord, then it's started from time. If no time is, then from the date of refusal. No?
If no such date is fixed,
Yes, then from the date of
when the plaintiff has noticed that performance is refused.
refuse, my lord.
So he
Now
will-
he approached after 8 years.
So he will say, I noticed the,
No, there is no cause of action. Now, what I am saying, trying to say, my lord, that he has to say that on such and such date he has refused. So he has to refuse. Now, the agreement to sale is equitable and discretionary power, my lord. So therefore, a person should not be slapped over his right. This is one aspect of the matter. Lordship, kindly have a look at the agreement, please. Lordship will find the agreement at page 20 in the appeal.
yes.
And without consideration amount, not a single not a single rupee he has paid, my lord. That's the interesting point. He said that 2,80,000 rupees I have paid, but no. Lordship will find in the agreement itself there was no acknowledgement. The altogether valuation was fixed for 3 lakhs. He said that, plaintiff said that I have paid 2,80,000 at the time of execution of the sale deed, and remaining 20,000 is balance. The Lordship kindly have a look at the agreement. It's a registered agreement. It is between the Debashish Chakraborty. Now I will come to that point that whether Debashish Chakraborty having any right to enter into an agreement or not, my lord, of 10 luchas of land. Whether he having a share of 10 luchas of land, I will come to that on the third submission. Lordship will kindly have a look here that the vendor is the absolute lawful owner and possessor of a land measuring 0 bigha 0 gota 10 luchas. He said, I am an owner of 10 luchas. He said it is his statement. Now, Lordship kindly have a look at the clause 2 at page 22, my lord.
Yes.
Yes. What it has been said, my lord, that the purchaser shall pay a sum of rupees 2,80,000 as advance, and the vendor shall issue valid receipt for the same. Kindly have taken note, my lord. No receipt was produced. No, and the vendor statement in his written statement and the written objection, that no payment was made. Specific stand. And no valid receipt was produced. So therefore, no payment was made on 11/8/2015, my lord. Now the another important clause is clause 6, my lord. That the vendor will execute final sale deed of the said plot of land after obtaining sale purchase permission as soon as possible.
Yes.
Now, my lord, the third submission, which is very, very important, my lord, that the question is whether this agreement is executable. My humble submission, respectful submission before this honorable court, my lord, that this agreement is itself not executable, which is overlooked by the learned trial court. Why I am saying so? The original vendor, admittedly Manju Chakraborty, mother of the vendor. The Manju Chakraborty died, expired. Now, at the time of execution, the land was stands in the revenue records in the name of the Manju Chakraborty, is the admitted position. Now, Manju Chakraborty died, and there are 5 legal heirs, my lord. This Debashish Chakraborty is son, and 3 daughters and 1 son. Though this son, the youngest son, he has separated, and later on the land was mutated in the name of Debashish, that is vendor of this agreement, and 3 daughters. 3 married daughters, who are the vendors of the land. So there are 4, my lord. 3 and 4, admittedly 4, after Manju. So the land is 1 cut. This is 20 luchas. 5 luchas is. So 5 luchas is how he can sell 10 luchas. Even for argument's sake, I am saying that yes, my learned brother's client may succeed in the suit. A decree be passed. Whether that decree, specific performance contract can be executable, my lord? No, because he has contracted the sale beyond his share. So he cannot, without, and that too, my lord, is undivided joint property. How can a equitable relief can be granted, my lord? Under Order 39, Rule 1 and 2. So therefore, my submission, my lord, before this honorable court, that is Devashish Chakraborty, without having any ownership of 10 loches of land, he has contracted more than his share. 5 loches. He has 5 loches. Even if 5 loches is contracted, then it's fine, my lord. But he is contracted with the sale with 10 loches.
Okay.
Now, Honor, can we have a look here? In another, otherwise also this agreement is not executable. Why I am saying so? Now, if this Devashish Chakraborty, even if he sold 5 loches of land, that is not sellable as per the rules, my lord, of the prevailing in the state. Because the minimum plot size would be 343 square meter, that is 1442 square feet. A person cannot sell below this. So if having a 5 loches of land, that comes to 720 square feet. He cannot. No permission would be granted. Even I am applied for permission, my lord.
As per what rule?
Is a building rules 2014. Is admitted position, my lord. Minimum plot size would be 1442 square feet. Under the urban local bodies.
For what?
For yes.
Or for
For residential, yes, for sale. Because the municipal corporation or municipal body, he would see the road, etc., plot size, etc. Thereafter, the permission would be given. Now, I cannot sell 300 square feet, 400 square feet. A minimum size should be there. Because otherwise, I cannot construct a house. So therefore, he having a power to sell only 720 square feet, he sell, my lord, 1400 square feet, double. So therefore, this agreement is not executable at all, even if decree is passed. So it is doctrine of impossibility, my lord. Now, honor will find. Now, kindly see the written statement and objection of the Devashish Chakraborty, my lord. Page 70, my lord. Page 70, para 18. Page 72. The specific stand by the vendor, my lord. Para 18, my lord. May I read, my lord?
Yes.
The answering opposite party, that is the vendor of the respondent number 1. The answering opposite party respectfully state that he has never claimed before the petitioner that he is the absolute owner of the suit land. The petitioner resides in the same locality. The petitioner was also aware of the opposite party's married sister and brother, and he was aware that the suit land was jointly owned. It is worth mentioning that during that period, opposite party number 1 had strained relationship with his sisters and brother, and they had no communication with each other. That despite knowing the fact that the property was joint property, the petitioner approached the opposite party number 1 to purchase the suit land. When opposite party number 1 denied the sale, citing joint ownership as the reason, and also stated that his share of the land in the joint property is not 10 locha, the petitioner falsely assured him that he had already spoken with the other co-owners and that they had agreed to give no objection. He further stated that he was ready to purchase 5 lochas of land. Believing his assurance, the opposite party number 1 agreed to the petitioner's proposal. Opposite party number 1 studied up to class 8 and is not able to read English. He is very simple in nature. Consequently, the petitioner engaged his advocate Shangita Dotto to prepare the agreement. The answering opposite beg to submit is Devashish Chakraborty, Ina Chakraborty, Meena Chakraborty, Chobi Chustami, and Sri Ashish Chakraborty inherited the land from their mother, late Manju Chakraborty, and mutation done on 28/8/2020 by case number such and such. And after that, on 27/4/2022, such and such, made partition of the land and become joint owner of the land measuring 1 kata 0.84 lucha of PP number such and such, such and such, such and such. Now, Lordship also kindly have a look at para 22, that he has specifically said that he has not received any money. Para 22, my lord, page 73, Lordship will find as page 74, last part.
Yes.
The answering opposite party also respectfully state that the petitioner has never paid any amount to him and he has never acknowledged any receipt of the advance amount of rupees 2,80,000 from the petitioner. That the petitioner paid not a single penny to the opposite party number 1, but made only a false promise to pay entire amount as soon as possible, but he has never fulfilled his promise. So therefore, it's a clear case of it's a misrepresentation before the learned court. And the agreement is clear that no acknowledgement, nothing. So therefore, no payment was made, my lord. Now, I am the bona fide purchaser of the land on 7/1/2025. From all the legal years.
We are in possession of the land.
Lordship, kindly have a look at the sale deed. That's page 82, my lord.
Okay.
82.
No, you have purchased it.
Most importantly, my lord, that the injunction, the impugned order, if a lordship see the balance of convenience and owing the hardship, we are more on the last corner, my lord. Because what happened, my lord, after purchase in March, we have obtained the permission. We have started construction, my lord, and we have substantially constructed. Lordship, that's in the trial court. They have filed the photographs. I am just for the perusal of the court. I just do the substantially. So we have already constructed the 2 floors, my lord. The small plot, and this is only residential. For residential purpose, we have purchased, my lord. So how they will prejudice, my lord, if there is no injunction order? If finally they succeed, my lord. If finally they succeed.
Where is the impugned order?
Impugned order, Lordship, will find in the appeal, we have at page 119, my lord. How the learned trial court not consider our stand, my lord? Lordship will find at page 122. We raised all these issues, my lord. 122, my lord. May I read?
Yes. Yes.
Second paragraph. The further contention of the opposite party number 2, that the C has paid full, this is our contention. The C has paid full consideration, obtained mutation and building permission, raised construction and invested substantial amount, and the stoppage of the construction would cause irreparable loss, cannot be accepted at this stage. Why? No explanation. It is well settled. It is well settled. The investment made on construction raised during pendency of a dispute on litigation do not create any equity in favor of a party so as to defeat interim protection. Learned trial court, my lord, for just having a misconception of the specific performance suit, equated with the other suit. The plea of bona fide purchaser without notice, alleged silence or delay on the part of the petitioner, readiness and willingness, entitlement, specific performance are all matters requiring evidence and final adjudication. At the stage of deciding an application under order such and such, the court is concerned only with the preservation of the property so that the lease does not become infructuous. The lease hardship to the opposite party number 2 is a consequence of our own acts. How it could be, my lord? I paid 26,75,000 and cannot outweigh the necessity of maintaining status quo. So this is basically the final observation, and therefore the Honorable Court finally comes to the at page 125. Lordship will find that find the prima facie case, balance of convenience, and also irreparable injury, said that we have not been injured by any order of the status quo. Now here 2 legal points I would like to place, and I also request this Honorable Court to look into, my lord.
How the balance of convenience?
Now I am saying so, my lord. Now Lordship will kindly there is no discussion, in fact. So he said, Lordship will find in the nowadays in the trial courts, in the injunction order, there is some pro forma, this order has been passed, my lord, otherwise in a format. So therefore, the prima facie case also Lordship will find there's 3 headings, the learned court saying so. Therefore, the injunction was made. Now the learned trial court could not, and I'm respectfully submit, my lord, the section 54 also not look into of the TP Act. Had it been learned trial court, look into section 54, which says, my lord, that the contract of sale cannot create any right about the immovable property. If contract of sale cannot create any right about the immovable property, cannot claim equity. Yes, you can, after the trial, you can get an order of the specific purpose. And recently the Supreme Court in 2025, my lord.
Agreement to sell.
Yes.
Agreement to sell.
Agreement to sell. Now, Lordship will kindly have a look at Transfer of Property Act. 44. 54, sorry.
Yes, you read slowly.
Oh, yes.
Till he.
Yes. 54, yes. 54 sale defined, my lord. I'm not concerned with this. Lordship is everybody we know. Sale how made. Now, in the last part of the section 54, there is a prefix, my lord, contract for sale. A contract for sale of immovable property is a contract that a sale of such property shall take place on terms settled between the parties. It does not of itself create any interest in or charge of the property. So therefore, by virtue of this contract, you have no right over the property. When you have a right, decree, my lord, not interim period. And Supreme Court in recent judgment of
Whereas you have purchased the land.
Yes, I am purchased, I am the purchaser. So the sale under section 54 has been completed in my favor. So the contract for sale, your case, you have no right over the property. Until get the decree, my lord. Now in 25 of Supreme Court, 25 SCC online, Supreme Court 1875, my lord, all these issues has been covered. Lordship will find in para 15. 25 SCC online, Supreme Court 1879. Lordship will kindly comes to paragraph 15. After the Honorable Supreme Court referred to section 54 in paragraph 13, as discussed in para 15, my lord. Lordship has got it.
Yes.
Yes. I'm referring paragraph 15. There is a
Yes, para 15.
There is a difference between a sale deed and an agreement for sale. I'm saying why, my lord, that how the title and the right, which greater than you, that I'm saying. There is a difference between a sale deed and an agreement for sale or a contract for sale. A contract for sale of a movable property is a contract that a sale of such property shall take place on terms settled between the parties. While a sale is a transfer of ownership, a contract for sale is merely a document, creating a right to obtain another document, namely a registered sale deed, to complete the transaction of the sale of an immovable property. Section 54 in its definition of sale does not include an agreement of sale and neither confers any property rights in favor of the transferee, nor by itself create any interest of charging the property. So therefore, you have a registered agreement, admittedly, got a decree. Before that, you cannot put any better claim than a registered sale deed owner. That's one of the contention. And second contention, my lord, in IA in paragraph 5, I'm saying, what I'm saying, my lord, that I have undertaken. What happened, my lord, even if there is an injunction, I will construct a building, my lord. I will reside there. And in the event of the decree, even a passed later on, even miserably, this barred by limitation, no right, nothing, even if decreed by a stroke of moment, then what happened, my lord? He will execute the sale deed. How you will execute the sale deed is a very difficult part, because no permission would be granted, even if he got the permission. And then in 10 luches he has purchased. Now that 10 luches include the sale deed. Then in that event, I have to deliver the possession by demolishing my building. This at my consequence, at my cost, and I undertake that I will do that. Lordship, kindly have a look at in the IA in paragraph 5.
Okay.
With affidavit I am saying, and supported by a judgment of the Supreme Court, I will place. First, I will place the judgment. Yes. 2009, my lord, paragraph 26. 2009-12 SEC 776 is a well-known judgment, my lord. It's referred by, we refer sometime when this such type of matters comes. 2009-12, Lordship, kindly have a straight away go to paragraph 26. 9-12 SEC 776. 26. Paragraph 20. 26. Got it, madam?
Yes.
Yes. It is well settled. It is well settled that when construction has been made on a land which is considerable magnitude, and which the plaintiff shall not face any substantial injury, if no order of injunction is granted because of payment deposit of the entire amount payable by the defendant to the plaintiff under the agreement, though belatedly, we are of the view that the court will not, as a matter of course, pass an order of injunction against the other party, restraining the other party from raising any construction on the suit property till the disposal of the suit. If ultimately, this is important, if ultimately the suit filed by the plaintiff, appellant plaintiff is decreed, he can be compensated in damage, or the respondent defendant may be directed to pull down the construction and deliver vacant position to the appellant plaintiff when no equity can be claimed for such construction by the respondent defendant. I'm ready, my lord. I'm in paragraph 5, my lord, in the IA, I have said specifically. Lordship, kindly take up the IA, my lord. In paragraph 5, my lord. I have already invested 60 lakhs rupees, my lord. 26 lakhs 75,000 my sale consideration, and again 60 lakhs in the construction. Paragraph 5, my lord, kindly have a look. Page 4.
Yes.
Made it.
Yes.
Paragraph 5, the last 4 or 5 lines, my lord. I am starting from BART. Paragraph 5, middle portion, my lord. But the learned court below by the impugn order directing to maintain status quo over the suit property till disposal of the suit, due to which the applicant has to stop ongoing construction work. The applicant is ever ready and undertake before this honorable court that if the plaintiff able to succeed in the suit, she will demolish the construction made over the suit land immediately. Thus, if the impugn order is not stayed with this honorable court, in that if not only the applicant suffer financially, but also it will affect the ongoing construction works. All materials will be damaged now, my lord. Now rainy season would come. All materials collected, the entire construction works, everything has been finished.
Okay.
I'm a bona fide purchaser. So I will undertake this before this court on an affidavit. So this my humble prayer, my lord, they will not suffer anything.
Can this appeal be disposed of today without issuing notice?
Because he has appeared, my lord, on the.
The respondent number 2 perhaps, or else he has filed his objection.
Yes, he has already filed his objection before the trial court, and no injunction against him. Injunction against me. I am the sufferer. He has taken the money and he's gone.
Yes, Mr. Dhar.
Yes. First of all, I just forgot, so after hearing my senior's argument, whether we are on the suit or on the application under order 39(1) and 2. I thought it's a mini trial going on like that. Anyway, my lord,
We are in the appeal.
we are in the appeal and appeal against the order of under passed under order 39(1) and 2.
The facts, on facts, you have to say something.
Yes, sir. That is, I'm very.
Otherwise, whatever I have heard till now,
Yes.
it appears that they have better title than you.
Obviously, my lord. But whatever they have submitted, let me just point out 1, 2 things. let us go first the agreement. What
Yes.
their agreement they have made with me. Page 22. Page 20. It starts from page 20. My senior has already read out the provisions. This is a registered agreement, my lord. This is not an unregistered agreement. Paragraph 2. The purchaser shall pay a sum of rupees 2,80,000 as advance, and vendor shall issue valid receipt of the same. So the vendor, respondent number 2, defendant number 1 in the suit, he has denied that I have not received any money. This is a disputed question of fact because he has to give a receipt. It is not like that. I have specifically mentioned I have given in cash 2,80,000, and in return he has to give a money receipt to me. Now let us go to paragraph 5. That after execution of this agreement, the vendor have no right to sell the aforesaid land to any third parties. Now the paragraph 6 is very important, that the vendor will execute final sale deed of the said plot of land after obtaining sale and purchase permission as soon as possible. So it's not me. It is the vendor. It is the agreed, registered by a registered deed of agreement that vendor shall execute the final sale deed after obtaining first permission. It's not the intending purchaser will obtain the permission and execute the final sale deed. Now he represented that he is owner of the entire plot of land, and out of that land he is going to sell 10 acres of land to me. Now another thing, Your Honor, Lordship, my Lordship has seen that the suit initially was filed on 3rd of December 2024. That is the first suit I filed for specific performance against the respondent number 2 herein, the vendor. Title suit number 68 of 2024. The date is very important. It is 3rd of December 2024. And prior to that, I have lodged a complaint before the authorities that has not been annexed here. Kindly. It's a document number 4 of the plaintiff, document number 4. Kindly see the date, 22nd of November 2024.
Yes.
And the purported sale to the petitioner appellant herein was executed on 7th of January 2025. Subsequently, in November, I filed a complaint. In December, 3rd of December, I filed a suit against the vendor. And in January 2025, the vendor and other persons have executed the sale in favor of the appellant. Now I come to section 52 of the Transfer of Property Act. Prior to going to section 54, we have to read section 52 of the Transfer of Property Act. The Lordship is, may I just read slowly section 52?
Yes.
Transfer of property, as you Lordship got it,
Yes.
section 52.
Yes, please.
This is the doctrine of lis pendens.
Is it?
Transfer of property pending suit there relating thereto. During the pendency in any court having authority within the limits of India, excluding the state of Jammu and Kashmir, or established beyond such limits by central government of any suit or proceeding which is not conclusive and in which any right to immovable property is directly and specifically in question, the property cannot be transferred or otherwise dealt with by any party to the suit or proceeding so as to affect the rights of any other party thereto under any or decree or order which may be made therein except under the authority of the court and on such terms as may impose. There is an explanation. For the purposes of this section, the pendency of a suit or a proceeding shall be deemed to commence from the date of presentation of the plaint or the institution of the proceeding in a court of competent jurisdiction, and to continue until the suit or proceeding has been disposed of by a final decree or order and complete satisfaction or discharge of such decree or order has been obtained or has become unobtainable by reason of the expiration of any period or limitation prescribed by the execution thereof by any law for the time being in force. So, the first question that the suit is barred by limitation, here my senior has rightly pointed out that if the time frame is not mentioned, then from the date, the limitation will commence from the date when it was refused. That is a disputed question. That becomes a disputed question which can be adjudicated after adducing evidence in the suit. Here, I have drawn your lordship's attention to clause 6, which says that the vendor will obtain the permission as soon as possible and execute the final sale deed. So though there is no time frame is given.
So you approached in the year 2024.
2024. When we smell some foul is going to happen in the year 2024, immediately after lodging a complaint before the authorities, revenue authorities, we file the suit for specific performance.
No, in cases of specific performance of contract,
Yes.
where no specific time is given,
Yes.
that means law of limitation would not be applicable. You can come even after 20 years for.
When it is, yes, my lord. That is, I have authorities, I will, if required, I will submit. When it was denied.
So
the limitation which that was the submission made by my senior counsel also.
So when you approach for seeking execution of.
I made the specific pleadings in my plaint. I was insisting, but when I came to know that something is going on in his mind, third party, he will create some third party right. In 2024, I approached him. He denied. He said, no, I cannot do. Then I lodged the complaint on 20th of this November 2024.
So is it your submission?
Yes.
Where the agreement to sale is silent about a specific date or time? You are at liberty to approach at any time.
No, I have no, not in liberty. The period of limitation will commence from the date.
That I want to understand. Here you have approached after 8 years.
Yes.
You could have approached after 20 years
No,
also.
I have approached before also, but he denied in 2024.
Okay.
I constantly, I was in touch, but in 2024, he said, no, I cannot sell it to you. So immediately thereafter, I lodged the complaint before the authorities.
Okay.
And in 2025 only, 2025, I lodged.
When the suit filed.
First suit.
First suit was title suit number?
Title suit number 68 of 2024.
It was filed on
3rd of December 2024.
When it was returned?
It was returned
11th November, perhaps.
11, yes,
2024.
2025,
When you have 11 November
2025,
2025.
yes. And no,
26.
no, no. It's prior to 13th of October 2025.
Because
Because the senior division, before the senior division, the suit was filed on 13th of October 2025.
11/9/25, madam.
Yes, 11/9. And the instant suit was filed on prior to that, when I came to know that during the pendency of title suit number 68 before the junior division, the defendant number 1, opposite respondent number 2 hearing has transferred the land in favor of the appellant hearing. We impleaded her before the junior division in title suit number 68 of 2024. When the issue of jurisdiction, pecuniary jurisdiction came, that was returned, and we filed before the civil judge. Prior to that, the junior division also has given an injunction order.
Specifically. You indicate case going.
And moreover, your lordship will note one thing, that if the defendant number 1, respondent number 2 had taken a plea that after 11 years or 10 years he has come, then what has stopped him from cancellation of this registered agreement? He was all along aware of this registered deed of agreement. He has not taken this plea that I have cancelled, I have rescinded the contract. But he has admitted in his written statement. But he has disputed that he has not taken any money. So these are the matters which are required to be, it's a question of law and fact. Now, if your lordship please to come to page 74, that is the written objection. Here that my vendor says the first line, it is the written objection filed by my vendor. He says the answering opposite party respectfully states that he
No, you
agreed-
don't have any vendor.
Yes, ma'am. Of respondent number 2,
Because land has been,
intending vendor.
Not now intending also.
land has
Now,
already been,
not intending the,
land has already been sold to
yes,
the appellant.
yes. I appreciate under section 54, there, I have no right, but the Honorable Supreme Court as well as our court has also held that I have a protective right over this plot of land. I will come to that. But prior to that, what the respondent number 2, the main defendant in his written objection has admitted. That is page 74.
Yes.
The answering opposite party respectfully states that he agreed to sell 0 bigha 0 katha 5 lasses for consideration of rupees 3 lakhs only, based on the false assurance given by the petitioner that the co-owners had already consented to the sale.
Yes,
Kindly see.
he's pleased that he agreed to
Fine,
sell
sir.
his share
His- his
on
share-
the ground that you will
No,
obtain.
he has not, this share is nothing, no pleading. There is no pleading regarding the shares. What has
5
come-
lechas,
Was, yes,
There's a pleading.
which according to other side is his share.
it is, he could have said that it's my share of the plot of land, 5 leches, I could have sold, and one plea to power to sell such and such area of land. This is not, I could not find, my senior may point out.
There's a
Building
pleading.
rules, as per the building rules, they cannot sell 10 leches, 5 leches, less than 10 leches, 5. I could not find any pleadings in this, into that. effect.
There no pleading for the building rules is concerned.
So that is something new I have heard today.
It's law point.
And it's okay, but that was not pleaded case. And he has disputed. The answering opposite party also respectfully states that the petitioner has never paid any amount to him, and he has never acknowledged any receipt of the advance amount of rupees 2,80,000 here from the petitioner. So this is also comes within the purview of a disputed question of fact.
What is your claim? When have you paid the advance amount?
I paid as soon after the agreement.
When? On the same date or
Date is not mentioned. Soon after the agreement, I have paid that amount. This is
you have
my
not stated any specific date and time?
In the plain, there is no.
plain. Date has been not been mentioned. On that date only, I have stated paragraph 8 of my of the plain. On the day of execution and registration of the said agreement for sale, the plaintiff has paid a sum of rupees 2,80,000 only in cash, and the defendant number 1 has duly acknowledged the advance sale consideration of 2,80,000.
If you have, just for
Yes, ma'am.
sake of clarification, if you have paid the amount on the date of agreement, why no such reflection was made to that effect in the agreement itself? If on the same date you have,
That was drafted in a not in a very happy manner, and but this becomes also interestingly in only in front of the witnesses and the deputy registrar Dibrugarh, and it was agreed between the plaintiff and defendant number 1 that the balance consideration of 20 lakhs will be paid to the plaintiff to the defendant number 1 to 20,000. So the witnesses are there.
okay,
Deputy registrar in front of whom I have paid, he is also there. So I have some witnesses to prove that he has already taken to.
so it is the question,
It's a question of fact.
trial.
Trial. It's a question of trial. By using evidence, I can prove it, even though it's not specifically stated that when I have given, but I have pleaded in my plaint that in front of these witnesses and in front of the register, deputy register Dibrugarh, I have paid 2,80,000 to the defendant number 1. Now, the taking the question of dependence again, this suit was instituted with before prior to execution of the sale deed. Your Honor has seen on 3rd of December 2024, I have instituted the suit with regard to the suit property, and application of objection is also filed before the, prior to that objection was filed before the deputy commissioner as well as other revenue authorities, and during pendency of the suit, having knowledge of the suit, the defendant number 1 has executed this sale deed dated 7/1/2025 to the appellant herein, defendant number 2. So if we take section 52 of the Specific Relief Act, Transfer of Property Act, this is also barred. Now, my lord, I would like to, I have nothing much more to say with regard to the facts, because these are all disputed question of fact which had needed to be adjudicated by a fair trial. And my lord, one thing my colleague has pointed out fairly, that in this order of injunction, what is the wrong in this order? What is the perversity? What is the arbitrariness in this order, impugned order? That has not been stated either in this appeal nor in verbal submission. And the order is very clear. Page 127. Irreparable loss starts with irreparable loss. Next paragraph. Yes.
Over the suit property, the construction has been substantially done, already done. It is even these up to first floor.
Ground, first and second. G+2 building.
So how it will matter if it is stayed now or?
My lord, one thing your lordship will appreciate. 1st of January 2025, during the pendency of my suit, the suit land, part of the entire suit land was sold to the defendant number 2. Now, by showing these photographs, I don't know whether these are.
But
In the plaint itself.
In
the plaint itself, my lord, I will show that they have filed the photographs showing that the construction is going on.
Please.
I will show the paragraph number. Plaint table show. Plaint is 24.
So that I don't know whether these photographs are those photographs, I don't know. But even again, these are questions.
I filed, my lord. Before the court, I have a duty to represent, not to misrepresent, my lord. I filed it with all responsibility, my lord. Paragraph 20, page 34, my lord. Ongoing construction. In the plaint itself, they say.
Okay. Complete your submission.
Yes, sir. Now,
Now, how you can injunct an owner to now he's having a better title than you.
Definitely, my lord. That is.
Though you are challenging the sale deed.
Yes. I am challenging the sale deed as well as I have a protective right over this suit property. Now, in a judgment of Supreme Court, I just would like to
attract when the appellate court can interfere with the order of injunction passed by the trial court. My lord, paragraph 21, 2024, 11 SCC 351. Ramakant Ambal Choksi. Yes. Wonder case has been discussed. Paragraph 21. In such appeals, the appellate court will not interfere with the exercise of discretion of the court of the first instance and substitutes its own discretion, except where the discretion has been shown to have been exercised arbitrarily or capriciously or perversely, or where the court had ignored the settled principles of law regulating grant or refusal of interlocutory injunction. The appellate court will not reassess the material and seek to reach a conclusion different from the one reached by the court below. If the discretions have been exercised by the trial court reasonably and in a judicial manner, the fact that the appellate court would have taken different view may not justify interference with the trial court's exercise of jurisdiction. Now, I will not trouble your lordship to other paragraphs. These are similar. 25, paragraph 25. What flows from a plain reading of the decisions in Evans and Charles' decision in Austin is that an appellate court, even while deciding an appeal against a discretionary order granting ad interim injunction, has to examine whether the discretion has been properly exercised, that is, examine whether the discretion exercise is not arbitrary, capricious, or contrary to the principles of law. And in addition to the above, an appellate court may, in a given case, have to adjudicate on facts, even in such discretionary orders. Then paragraph 26. The principles of law explained by this court in Wonder 7 have been reiterated in number of subsequent decisions of this court. However, over a period of time, the test laid down by the court as regards the scope of interference has been made more stringent. The emphasis is now more on perversity rather than a mere error of fact or law in the order of granting injunction pending the final adjudication of the suit. In Neon Laboratories Limited versus Medical Technologies Limited, this court held that appellate court should not whimsically, or lightly interfere in the exercise or discretion by a subordinate court unless such exercise is palpably perverse. Perversity can pertain to the understanding of law or the appreciation of pleadings or evidence. In other words, the court took the view that to interfere against an order granting or declining to grant a temporary injunction, perversity has to be demonstrated in the findings of the trial court. Then, in Muhammad Mehtab Khan versus Khushnuma Ibrahim Khan, this court emphasized on the principles laid down in Wonder 7 and observed that while the view taken by the appellate court may be an equally possible view, the mere possibility of taking such view must not form the basis of setting aside the decision arrived at by the trial court in exercise of the discretion under Order 39 CPC. The basis for substituting the view of the trial court should be malafide, capriciousness, arbitrariness, or perversity in the order of the trial court. The relevant observations are extracted below. In a situation where the learned trial court, on a consideration of the respective cases in the parties and documents laid before it, was of the view that the entitlement of the plaintiffs to an order of interim mandatory injunction was in a serious doubt, the appellate court could not have interfered with the exercise of discretion by the learned trial judge unless such exercise was found to be palpably incorrect or untenable. The reasons that weighed with the learned trial judge, as already noticed, according to us, do not indicate that view taken was not as a possible view.
The appellate court therefore should not have substituted its view in the matter merely on the ground that in its opinion the facts of the case call for a different conclusion. Such an exercise is not correct parameter for exercise of jurisdiction while hearing an appeal against a discretionary order. While we must not be understood that must not be understood to have said that the appellate court was wrong in its conclusions, what is sought to be emphasized is that as long as the view of the trial court was a possible view, the appellate court should not have interfered with the same, following the virtually settled principles of law in this regard as laid down by this court in Wonder Limited versus Antox India Private Limited. Now, I'm not reading the other paragraphs and principles governing grant of temporary injunction. Your lordship will find from paragraph 32 onwards. I'm not troubling your lordship. And the meaning of perversity that has been dealt with from paragraph 34. The definitions of perverse has been given in this judgment. I'm not reading for the sake of I'm just reading paragraph 37. Since in the light of the aforesaid settled position of law, where of the clear view that in the facts of the present case, the High Court overstepped in its appellate jurisdiction under Order 43 CPC and substitutes its own view for the one taken by the trial court without giving any categorical finding as to why the order of the trial court could be said to be suffer from any perversity, capriciousness, arbitrariness, malafidis, or having been passed in ignorance of the settled principles governing the grant of injunction under Order 39 CPC. After discussing all this perversity, the principles for granting order of temporary injunction, the Honorable Apex Court has held this. And I have also relied on paragraph 40, 44, 45. Now, in the present case, as said by my learned friend, I am also disputing this. The construction work for third floor, so second floor or third floor has been already completed. Now, if the present defendant creates any third party interest over this land, and if I succeed, then what will happen? If this sale deed is declared null and void, then what will happen? That is why what has to be decided in the trial. That is why to protect the suit property from third party creating any third party interest, this status quo order has been given by the trial court. What I can understand from my limited analysis. Just
status quo as regards alienation only.
No, it says status quo. Status quo. May I just read again the order, page 127. It's next paragraph to irreparable injury. As your lordship got it, the plea
Yes.
that opposite party number 2 is a bona fide purchaser for value without notice involves serious questions relating to notice, conduct of parties, and timing of transaction. There are matters of trial and cannot be conclusively determined at this stage, because learned trial court has taken note of this fact that earlier during the pendency of the suit before the junior division, that is the defendant number 1, here the defendant number 1 has transferred the suit property in favor of the defendant number 2. That is why the learned civil judge senior division has mentioned that the plea that the opposite party number 2 is a bona fide purchaser for value without notice involves questions relating to notice, conduct of the parties, and timing of transaction. There are matters of trial and cannot be conclusively determined at this stage. Already created a third party right. The defendant number 1 has already created a third party right after execution the registered agreement for sale with me and with the rider in the this agreement for sale that he will obtain the permission for sale. And he will do the everything for execution of the final sale deal. Now, in the next paragraph, in view of the above discussion, this court is satisfied that all the 3 essential requirements for granting temporary injunctions stands fulfilled. Accordingly, in view of the discussion made above, both the parties are directed to maintain status quo as on today with respect of the suit property till disposal of the analogous title suit bearing number 111 of 2025. What is the wrong? What is the perversity in this order? Because if she continues to construct, then she may again create third party interest, that multiplicity of the proceeding. Now, another judgment of the coordinate bench of our High Court, Lordship. I could not find this judgment in either GLT or SCC online.
What it says?
This is a case where the injunction was not granted by the trial court. The injunction application was dismissed. Here also, in paragraph 24, the judgment of Wonder Limited versus Antox India Private Limited has discussed in paragraph 24. And in paragraph 26 onwards, it says from the materials on record, there is no denial that defendant respondent herein had executed the registered agreement for sale dated so-and-so. There is a dispute as to whether the possession of the suit land was handed over to the plaintiff and then the plaintiff was dispossessed. The plaintiff categorically stated that she had paid an amount of rupees so-and-so and in that regard relied upon certain documents. The said aspect, however, have been denied. The question as to whether such a payment has been made or not is a subject matter of trial. But for the purpose of an injunction, it is the opinion of this court that there is a prima facie case for going for trial. More so when the plaintiff had categorically pleaded that she was ready and willing to perform the hard part of contract. Now, paragraph 27. Now, let us this court take note of the second aspect of the as to whether the balance of convenience was in favor of the plaintiff for the grant of an injunction. Competing claims being looked into by this court, it appears that if an injunction is not granted and third-party rights are being created, it would lead to multiplicity of the suit and it would further be difficult for the purpose of passing an effective decree. It is also relevant to observe that post the 2018 amendment of the Specific Relief Act 1963, grant of the relief of specific performance is no longer discretionary but obligatory. Considering the above, it is the opinion of this court that there is a balance of convenience for grant of injunction in favor of the plaintiff. So, in paragraph 28A, while allowing
What is this amendment of 2018?
Specifically,
What relief you are seeking in the plaint?
yes. My prayers, your lordship will find for page 43. A, declaring that defendant number one in compliance with the agreement of sale bearing so and so is duty bound to execute the registered deed of sale of the suit land described in the schedule. And B, for specific performance of contract. C, for decree of delivery of khas position. D, for declaration that the sale deed executed in favor of defendant number two is illegal, void, inoperative, and none is in the eye of law. And the mutation done, hurriedly done during the pendency of the suits is in the favor of defendant number two is illegal, void, inoperative, and none is in law. And the partition done by circle officer is none is in the eye of law, and so for issuance of precept.
What is this 2018 amendment?
Amendment of subheading under chapter 2. Section 19. Section 19 is relief against parties and persons claiming under them by subsequent title. Here in 9.
In what context the court made observation regarding amendment of 2018?
That is reflected in the judgment. Perhaps amendment of section, substitution of new section for section 20. Substituting contract. Substituting contract. Substituted performance of contract.
Yes, anything else?
Nothing more. Now, the only question is that if the status quo is not maintained by both the parties and the defendant number two, who has allegedly purchased during the pendency of a litigation from one of the intending seller, that is the defendant number one, who has agreed to sell the property by taking amount from him.
Not only from defendant number one, also from other co-sharers.
Other
That is his claim.
These are disputed because I personally, I have entered into agreement with one person, that is the defendant number one. He agreed to, he himself impersonating himself to the owner of the entire land. If your lordship sees the agreement, he says, I am the owner, absolute owner of this land. Thereafter, after 11 years, 10 years, the brothers, sisters, mothers, they come and they sell the entire property to defendant number two.
Let him file an FIR, my lord. This is good, without specific performance.
That will do definitely, because this.
If a person impersonating and entered into an agreement, that agreement itself is void.
So that's what we have.
That's
sought
his
for.
submission, my lord,
That's
finally.
what we have submitted.
That's his final submission. That his vendor, that at that time, he impersonating himself to be the owner. If that being so, his submission, my lord, then the entire agreement will go. In reply, my lord, why we say it's a perverse, an appellate court to be interfered, my lord. The learned trial court overlooked the statutory provision. Number one, section 54. Number two, my lord, section 17 of the Specific Relief Act. I would not say so much, but since my learned friend has says, so I have to let this honorable court to look into section 17 of the Contract Act, because this contract is not enforceable as per section 17. Specific Relief Act. Contract to sell or let property be who has no title, not specifically enforceable. Section 17, kindly see. But that section 17 also learned trial court statutory provision overlooked. Admittedly, he has no title. Admitted. Because my learned friend, though argued a lengthy argument relying upon so many judgments, enlightening all of us, said that whether that person Devashi is having a title of 10 luchas or not. He has filed the Jamamandi with the plaintiff, my lord. And in the Jamamandi, in the records, it's reflected who are the owner. Lordship will find, because I'm sorry, my lord, that I would taken the much judicial time. But Lordship kindly have a look that in certificate.
You are
Yes,
complete.
in paragraph 20, my lord. In paragraph 20, so he has knowledge. In paragraph 20, page 34, he has filed the Jamamundi copy. And in the records is reflected who are the owners. So therefore, he has no title. So section 17, what says, my lord? If he has no title, so that contract cannot be enforceable. He having a title of 5 luchas, and that too undivided joint property. A contract to sell cannot be specifically enforced who knowing not to have entitled to the property. And my lord, this section 41E also forbidden the trial court to grant any injunction. Because E says, 41E of Specific Relief Act, to prevent the breach of contract, the performance which would not be specifically enforced. It cannot be enforced, my lord. You contract with 10 luchas land, he having a title of 5 luchas of land. How could this contract can be enforced? No imagination, my lord. Not remote imagination, this contract can be enforced. So therefore it is also forbidden by law. Section 23 of the contract it would come. If it is forbidden by law, then it's unlawful, this contract. And if they defeat the provision of any law, the section 23 says that the consideration and object of an agreement is lawful unless such in nature is permitted, it would defeat the provision of any law. It defeats the provision of section 54. It defeats the provision of section 17. It defeats the provision of sections 41E. That's my submission. Lordship may, I let this honorable court may decide.
We have taken much time.
Yes, my lord, we should not. So for the appellate court powers is concerned, my lord, is a settled position. In fact, my learned friend has placed a judgment of coordinate bench. We contradict that, yes, the appellate court grant an injunction. So it is my favor.
Heard Mr. B. Datta, learned senior counsel assisted by Mr.
J. Das.
J. Das, learned counsel for the appellant. So heard Mr. A. Dhar, learned counsel appearing for
Respondent number 1.
respondent number 1.
My lord will discharge the caveat.
Respondent number 1 / caveat. This appeal under order 43 rule 1 within bracket R of the Code of Civil Procedure 1908 has been preferred by the appellant Srimati Sarla Poddar, impugning the order dated 24/2/2026 passed by the Court of Learned Civil Judge, Senior Division, Dibrugarh, in Miss J case number 140/2025, arising out of title suit number 111/2025, whereby both the parties, that is the appellant as well as the respondents herein, were directed to maintain status quo in respect of the suit property. Stop. Since Mr. Edhar has appeared as since Mr. Edhar has appeared as engaged counsel for the respondent number 1. Respondent number 1.
Plaintiff.
1. Hence, no formal notice is required to be sent to the said respondent. It is also submitted at bar by the learned counsel for both sides that we are waiving notice to respondent number
Yes,
2.
because he's a necessary parties, but so for the injunction is concerned,
That as the impugn order has affected the appellant, mainly the appellant. Hence, for deciding this appeal, the presence of respondent number 2, presence of pro forma respondent, namely Devashish Chakravarti, who is the vendor of the present appellant in respect of the suit property, may not be necessary. Hence, it is prayed that the notice to the said respondent may be waived. Considering the submissions made by learned counsel for both sides, and considering the facts and circumstances of the case, notice to respondent, the pro forma respondent is waived. And this appeal is taken up for final hearing today itself. Since the impugn orders and other relevant documents are annexed with the memo of appeal, this court is also not inclined to call for the records of Ms. J case number 140/2025. 140/2025. 2025, in which the impugn order has been passed. Stop. I'll dictate it in the
Yes,
chamber.
yes.
On Monday, I will deliver.
Right. Grateful.
Heard so and so. Let this matter be fixed for delivery of orders on Mondays. 16/3/2026.
Grateful.
Obliged.